Well, hey, everybody. Welcome back. It's been a minute. Hope you guys are all having a fantastic summer. As you know, I've said many times on the channel, I was getting ready to gear down and do the trial coverage in this case. I think jury selection was supposed to start on July 30th, and they were anticipating the case to run through about the middle of November. So, once we wrapped up the Karen Reed case, decided to have myself a little summer. So, boy, it was a beautiful, beautiful Monday afternoon when I took off for a little R&R out in the mountains. I'll show you guys where I was. I was out in the beautiful, beautiful, Goat Rocks of Washington. And it was probably, 1, 2 in the afternoon. And this is out by a little town called Packwood, Washington, off of Highway 12, and about 16, 17 miles or so down a old Forest Service road. So needless to say, this is not an area with great cell service, but I had a wonderful 3-4 days out in the wild. He's camped at this lake. It was just spectacular, beautiful. I went with my friend Heidi. We would hike all day and then paddle all afternoon. Just had an absolute blast. And Thursday afternoon, we drove back and get into cell signal range. Bing, 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 bing. My phone is blowing up. And so I knew something happened, and I think the best clue I got was the text from my mom. I probably still have it. In my phone somewhere. But Andrea, you can't go camping. Bryan Kohberger is going to plead guilty. What? Unexpected, guys. Very, very unexpected. And of course, this is Thursday. They had the plea hearing on Wednesday. It's like it's all tight. It's all wrapped up with a bow now. So I'm playing catch up at that point. And so that's my story about why I wasn't here when Bryan Kohberger pleaded guilty. Couldn't do that live. Had no idea it was happening. This is one of those cases where I think the main reason why it was such a surprise that the guilty plea came in was because of the gag order, because of the restrictions on transparency that we've had pretty much from the inception of the case. And so it's just made it very, very difficult to be able to assess, what's likely to happen here. What are we going to see? What are the kinds of strategic calculations the parties are making? And so all we had really known up until this point was what's in the probable cause affidavit, and then just few little drips and drabs of information that came out through the course of different various motion hearings. And a lot of that wasn't really painting the best picture about how the investigation had been unfolding. We had representations being made in court about how much of the reporting about the case, some of the factual reporting about the case, it was simply flat out wrong, incorrect. A lot of examples of that in the motion to change venue that came out. Probably the most prominent one was the allegation that he had stalked the victims, and the prosecuting attorney and the judge both, definitively went on the record. No, there is no evidence of any of that. He did not stalk the victims. Can't prove anything like that. So don't know where these types of news reports are coming from. And it's just part of the poisoning of the well that led to venue being changed to Ada County. We had heard that there was no known connection between Bryan Kohberger and the victims. We had learned that despite thorough searches, the police had not found any kind of transferred DNA, any victim DNA in his vehicle. in his apartment. No clothes, nothing like that. That was providing some kind of direct corroboration of involvement in the crime. And so really the first hint to me that perhaps there's going to be more here to come out was during the motions in limine. When we started seeing motions in limine are generally going to be challenging specific items of evidence for one reason or another, just arguing that it's not admissible in trial. And there was one that definitely stood out to me. One that stood out to me was the allegation that police were going to be able to prove that he had purchased a K-bar knife and sheath back in earlier in the year in 2022. The way the motion was presented kind of made it sound like perhaps there was little bit of issues with the proof of that. Was apparently done on a family account, but we got a response from the state that seemed to indicate pretty clearly now there was a Kohberger, there was a knife, and regardless of who purchased it, how they purchased it, or whatever, it was shipped to Bryan Kohberger at his parents' house in Pennsylvania. And this was really a pretty significant game changer in my mind for a couple of reasons. One, obviously, when Bryan Kohberger was arrested, police had searched his apartment. They searched his parents' house. They searched his belongings. They searched his vehicle. They searched everything that they could get access to, and never found a knife. Never found a knife sheath. So this is what in the defense world we call a bad fact, a really bad fact. This is a really bad fact, guys. And the main reason why is because best piece of evidence so far that anybody had ever known about tying Bryan Kohberger to the crime was the knife sheath that was found in the bed near Madison Mogen, and had trace DNA on the snap that was ultimately compared to Bryan Kohberger's DNA. High probability that it's Bryan or somebody closely related. And so this was going to be an issue in terms of how to handle that at trial. It kind of always was. And we saw how the defense theory was developing there, that this was it's trace DNA. So it's not like a blood drop. It's not saliva. It's not something that might tell you a little bit of a story about how that DNA ended up on that knife. And the defense was pretty clearly pursuing a secondary transfer theory. There was, again, motions in limine dealing with expert testimony, language to be used to describe the DNA and so forth. The problem, though, is that when you have now, you can put a K-bar knife in Bryan Kohberger's ownership. You didn't recover a K-bar knife when you searched all of his property. You're asking the jury to accept quite a lot if they are to buy into the theory that this is a unrelated K-bar knife that just circumstantially ended up with his DNA on it, and not in fact the K-bar knife that he himself bought back in earlier that year and was never recovered. So it was going to put the burden on the defense to have to explain that. And it's not going to be easy. What happened to your knife? What happened to your knife, Mr. Kohberger? Where did it go? And if you don't have a, pretty good and probably pretty substantiated explanation for that, like, here, it was stolen and I filed a report at the time, that would probably cut it. I didn't have my knife. And that would also explain why your DNA was on it. But if you don't have something like that, it's not going to be good. It creates a situation where there's a lot of pressure. Number one, you potentially now really have to put Bryan Kohberger on the stand to explain what happened to the knife. Where is it? And if you don't have any way to corroborate what his account for that would be, You're putting, you're really gambling with a man's life based on what the jury thinks of his credibility. And kind of part of the overlay of this whole case in any death penalty case is when you are dealing with a jury that is going to have to be pre-qualified to impose the death penalty, meaning anybody who is opposed to the death penalty, moral reasons, religious reasons, really any reason at all, isn't going to be willing to impose that kind of penalty. They're not going to be qualified to serve. And so there's, I meant to look up, I don't have an actual number for you on the likelihood, but there are plenty of studies on the difference between death qualified juries and just normally qualified juries that show that death qualified juries in general, much, much, much more likely to convict somebody of the crime that they're accused of. So big uphill battle once that information came out. So still wasn't really expecting this, just because everything had kind of been geared up towards getting ready for trial. Still not the strongest case in the world, but definitely some bad facts that you got to deal with. But I'll tell you what does not surprise me about this process was the speed with which they sought to wrap it up. Because it's very easy. Anybody who has worked in criminal defense has had plea deals blow up. Somebody sees the light one day and talks themselves out of it the next. And so the judge is going to know that, the state's going to know that, and Taylor is going to know that if they are in fact going to get this thing resolved. It's just in everybody's interest to treat it as if time is of the essence. Legally speaking, it's not, but practically speaking, of course, we know they've got massive amount of prep work that they have to do to get the jury in and prepare for the trial to go forward and so forth. So here's what I'm thinking about doing today, guys. I'm not planning to watch the entire hearings. They're out there, they're available. What I want to do is just kind of go through sort of what my thought process was as I got this information, and kind of look at some of the bits and pieces of the hearings to just kind of talk about what the takeaways are from this. So I got some big picture takeaways about what's happened. From a legal standpoint, it's about as over as a case can get. Okay, I'll say that right now. It's about as over as a case can get. And that's not just from a trial standpoint. Obviously, we're not going to have a trial. Appeal standpoint, he waived his appeal. We'll talk a little bit about that because of some comments that the judge made about, you waive your right to appeal, but you don't really waive your right to appeal. But guys, yeah, like you really do pretty much waive your right to appeal. But then there's also post-conviction, and not a real good prospect of post-conviction relief in this case. So from that standpoint, this resolution certainly did give, it gave everybody finality. I mean, it's over. It's done. From the official case standpoint, the case is solved. It's going to be closed, and that's that. But I'm sure I am not the only one out there who finds this kind of dissatisfying. It's kind of dissatisfying, isn't it? And again, so much of it is attributable to that gag order, because we weren't able to know what they did, what did they look at, what did they rule out, what other information did they have. All of that type of thing. It's just been such a murky view of what happened, and I'm not all that sure we're a lot closer today as we sit here. So when I heard, of course, there was a plea deal, like, oh my gosh, Gotta go take a look at this. Gotta see what's going on here. What does it mean? What is the deal? And so the very first thing that I went and did was I went and looked at the plea agreement, guys. The plea agreement. So let's look at it. Tell you what I took away from it. So he's pleading guilty as charged. First thing I noticed, all of the charges, but notice not to aggravating circumstances. He did not plead guilty to aggravated circumstances, the charges themselves. So the defendant will be sentenced to 10 years fixed for count 1. Defendant will receive fixed consecutive life sentences for counts 2 to 5. Now, when they say the defendant will receive, they don't have control over that. It's up to the judge. But this is pretty clearly indicating it's going to be a joint sentencing recommendation. The reason why I bring up the no plea to aggravating circumstances is because it did create a little bit of a legal question for me, a little bit of a legal sticky ground. And so I'll show you why that came up for me. And that is because of this statute right here. So small. Homicide. And so this tells you what the punishment is for murder, okay? So every person guilty of murder in the first degree shall be punished by death or by imprisonment for life, provided that a sentence of death shall not be imposed unless they filed the written notice of intent, which they did. And whenever the death penalty is not imposed, the court shall impose a sentence. So if there are aggravating circumstances beyond a reasonable doubt, but the death penalty would be unjust, then you get a fixed life sentence. If there is not a finding of statutory aggravating circumstances beyond a reasonable doubt, the court shall impose a life sentence with a minimum period of confinement of not less than 10 years, during which period of confinement the offender shall not be eligible for parole or discharge or credit or reduction of sentence for good conduct, except for meritorious service. Shall is mandatory language. Anytime you see shall in a statute, it's a pretty, now, the law is never 100%, guys. They always find a way under the right circumstances to say, no, shall doesn't really mean it's obligatory, and sometimes means or. There's all kinds of language games that get played in interpreting what statutes mean. But by and large, when it says shall, it means the court doesn't have discretion here. This is what you have to do. And so it would be life with eligibility for parole in 10 years. That's the normal mandatory sentence for non-aggravated first-degree murder. But that isn't what we pleaded to here. However, since this is the agreement, he's going to get fixed consecutive life sentences. Defense doesn't get to complain about it. They don't have a basis to go to, for example, the Court of Appeals, say, hey, the statute says it's got to be life with eligibility for parole in 10, unless there's aggravating circumstances. They didn't find aggravating circumstances here. I didn't plead to any aggravating circumstances, so there isn't a legal basis for this sentence. And take line 3, or reword line 3 in this plea agreement, and you've got a good legal argument, but he stipulated to it. So it would be invited error. He doesn't get to go complain about a sentence that he himself agreed that he would receive. The state can seek restitution orders regarding funeral expenses, crime victim compensation reimbursement. That all is very, very normal. The defendant understands the nature of the charge, not coerced. He understands the consequences of pleading guilty. He understands that by pleading guilty, he's waiving these various constitutional rights. He's satisfied with his legal representation. He's reviewed all possible defenses, and he is voluntarily waiving everything based on his constitutional rights. That is also pretty standard. That's the nature of a guilty plea. You are giving up the protections that the trial and appeal processes afford you. And the defendant understands that if he were to proceed to trial, he would have a right to appeal, including but not limited to issues decided by the court prior to the defendant's guilty plea. the judgment, including the findings of guilt and the sentence. This is real important, guys, because this is something sometimes people don't understand. We had a lot of pretrial motions in this case. You could argue maybe some of those decisions were wrong. Hypothetically, some of these decisions were wrong. I'm not saying definitively they are. When you plead guilty, you give up your right to appeal any of those decisions. You are essentially accepting them as valid. So anything that would potentially affect your guilt, affect the conviction, evidence that's produced, anything like that, no, you waive that. You waive that when you plead guilty. So all of those pretrial rulings, final. They are final, not subject to challenge. The defendant understands that if he were to proceed to trial, he would have the right to file a motion under Idaho Criminal Rule 35, seeking a reduction of the sentence. He hereby knowingly, intelligently, and voluntarily waives all rights to appeal any and all issues in this case, and waives the right to file a motion pursuant to Idaho Criminal Rule 35. I, of course, had to go look up Idaho Criminal Rule 35. And it's just a process that they have to correct or reduce a sentence. So it's this subsection B here, where within 120 days of the entry of the judgment, you can file a motion if the sentence has been imposed in an illegal manner, or to reduce it if you essentially, I think it's unfair for pretty much any reason. So it's just considered on the writings, and don't have any sort of hearing based on that, unless the judge wants to. This up here, however, is kind of important. You really can't waive your right to impose an illegal sentence. Okay, your right to not be subject to an illegal sentence. And the example of that would be, okay, he's waived his right to appeal. We go through the sentencing hearing, and let's imagine Judge Hippler sentences him to death. You can't do that, right? That's not legal. It doesn't comport with the process that's required to impose a death penalty in the state of Idaho. But he waived his right to appeal. No, you can't do that. Like the court is always going to allow you to appeal a sentence that is not it's not it's not in accordance with the law. So this is essentially the very, very narrow little appeal pathway that still exists in spite of a waiver of the right to appeal as part of a guilty plea. There are some very other extremely limited pathways. One of them would be if there was reason to question his capacity to be able to enter the plea. Is he competent, basically? And not just is he competent, because that can open up, post-conviction issues. Like, does he, do we have a record that would tend to show that he was not competent? For purposes of appeal, you're really talking about a situation where if the court knew there was some type of issue with competency, but went ahead and proceeded and took the plea anyway, yeah, you can typically appeal that. Very, very narrow little circumstances. If you are, if it's in the record that shows you were, for example, misadvised of some of the consequences of the plea, they told you incorrectly what you could be sentenced to. They told you the maximum sentence was less, for example, than you were potentially subject to. That will often render your plea not knowing, intelligent, and voluntary. So that's the type of thing that you can appeal. But pretty narrow little pathways. Don't really think any of that's going on in this case, guys. There were some issues raised about Bryan's psychological profile. Appears he has autism. As far as we know, that's the only diagnosis that he has from a don't really want to call it a mental health standpoint. Autism isn't a mental health disorder, but basically no indication of other types of pathologies. There was a diagnosis. Now I can't remember the name of it off the top of my head, but it was uh, like a movement type of disorder. Uh, but again, no antisocial personality disorder, no narcissistic personality disorder. Nothing along those lines, as far as we know, that has ever been disclosed in anything that has been filed. So that was the plea agreement, and that's pretty much all there was to it, right? These 6 things. He pleads guilty to all the charges, but no aggravating circumstances, but he's still stipulating to the fixed life sentences. Everything else pretty standard. So the thing that I was looking for on here he signed it, so everybody's in agreement on this. The thing that I was looking out for in this plea agreement that I wanted to see was, does this preclude an Anders plea? Does this preclude an Anders plea? So an Anders plea is based off a U.S. Supreme Court case that says, basically, we recognize that there are situations where a defendant maintains their innocence of the charge, but they recognize you're probably going to get convicted. And so you want to take advantage of a plea bargain that's being offered to you. Basically, it's a compromise type of deal. I'm still innocent, but I don't want to take the risk of getting a serious consequence at trial. I'm getting a benefit by pleading guilty. I want to go ahead and take that benefit and give up all of my rights. So an Anders plea, would kind of murky the waters, in terms of what does that mean for the case? What does that mean for the case in terms of what we know and what the actual facts are? But so nothing in the plea agreement prohibited him from doing that. That is something that happens sometimes, not always. But some prosecutors do, kind of, it's something very specifically that they consider. I might have expected it in this case, just given, of course, the nature of the crimes, and the fact that the families are going to want to know, is he admitting that he did it or not? And so if he is not going to admit that he did it, he's still going to take the death penalty off the table. Because guys, when you look through that plea agreement, there's not a lot of inducement to the state in there, is there? I mean, I really didn't see a whole lot of benefit that the state is giving out of this plea agreement, besides just, we don't have to go to trial. But at least in terms of the Anders plea, it doesn't appear that was really anticipated as an issue, because they did this written factual basis, and this is signed again by Bryan Kohberger. I hereby admit responsibility. Admit responsibility to each and every count, each and every victim. What does that mean? What does that mean? What it is not, what it is very definitively not, is Bryan Kohberger saying, I'm innocent, but I want to plead guilty because I want to get the benefit of this plea agreement. It is not that. But it's pretty minimal, isn't it? I hereby admit responsibility. Well, legal responsibility doesn't tell us anything about what, why. And I think that is kind of a little bit of what's very unsatisfying about this case. Because that's $1 million question. That's like the one thing that everybody wants to know is why? Why, how, So we'll talk about that a little bit more, because it comes up in the course of the hearings. Both, I mean, it's come up multiple times. Comes up in the sentencing hearing. Comes up in the press conference that they did afterwards. Which, guys, I'm not gonna play any of that. Um, but he gives his explanation for why he didn't kind of require that as part of the plea deal. And so we're going to talk about that when it comes up. But at the end of the day, I know that at least some of the family members are very not happy with this. And I got to tell you, I can understand that. I really can. I can understand that. Um, they want to know why. They want to know why. Everybody's going to want to know why. And not just the family members, guys, but Dylan and Bethany. Oh, Dylan and Bethany, they spoke at sentencing. Bethany wasn't there personally, but she did write a letter. Dylan was there to testify personally. Um, something that has always been a real specter in this case for me is Dylan and Bethany, and just the survivor's guilt that you would have going through a situation like that. They would want to know why not us? Wouldn't that be helpful? Potentially? I don't know. I don't know. But I know Bethany mentioned it in her statement how uh, she'd woken up at 7, like 7 in the morning on the 13th. She had a toothache. So she called her father. Her father's a dentist. Ultimately, she went back to sleep and didn't wake up until a little bit before noon. And she, made a comment about how, if there was any way to go back and change, even though she knows there's nothing that could have been done, if you had called 911 instantly, it still wouldn't have changed anything, given what we now know was inflicted on these 4 students. She still is just racked with guilt, about not having done that. And Dylan didn't discuss it, but I can't imagine. I can't imagine that you wouldn't spend the rest of your life wondering why them and not me. It's just the most natural thing in the world. And so, there was potentially an opportunity here to get an answer to that. But it wasn't part of the plea. It wasn't a condition of the plea. So I got to tell you, I found it a little strange. I found it a little, I don't want to say alarming, but very disappointing. Very disappointing. Um, you guys might remember Gary Ridgway, the Green River Killer. It was a very high profile case up here in Washington many years ago, and he ultimately entered a plea agreement with the prosecution in his case, where he did agree to plead guilty, and they took the death penalty off the table. But part of the condition for that was that he would have to, provide a full accounting of his crimes, including ones that he hadn't been charged with, including helping to locate and identify remains that hadn't been located. The focus was on helping get the families, the victims, closure. That was a critical element of that plea agreement, and we didn't get that here. So Mr. Thompson has his explanation why, and we'll go over that when we get to it. But I'll tell you what my concern was, and what I really would have liked to have kind of been taken off the table, and unfortunately, I don't think was for me. And that is that the impetus for this guilty plea and the reason to avoid trial, which is the only benefit the state is getting out of it, right? The only benefit that they're getting is we don't have to go to trial. Why wouldn't you want to go to trial? Sure, it's expensive. It's going to be time consuming. Um, but there is a vindication component to that. It's the reason why we have public trials in the first place, is to show the world what happened. What happened at 1122 King Road? And then show, why do we think and know this person that we've charged is responsible. So it's kind of an important it's an important social function that's served by having a trial, and we all get to look at the evidence and evaluate it and think about, is this just? What would be just? This is just part of the process of evaluating if the systems are working the way that we expect them to. I would hate to think that, it's just a money issue, and I don't think it is. And they've thrown millions. They've thrown millions at this case. Okay, I don't think it's a money issue. I don't think it's a time issue. I don't think it's a convenience issue. So what concerned me is that it was an embarrassment issue, because we had already heard in different parts of the pretrial process some potentially concerning things about the investigation. We knew, for example, that the FBI went into the IGG databases, into the private parts of the databases that they were specifically excluded from. They went in there anyway. We knew that the FBI had violated their own policy for making an arrest based on IGG when they did not have a confirmatory DNA sample from Bryan Kohberger. They did the trash pull. They only got Bryan Kohberger's dad. Maybe that's a technicality. Nevertheless, it shows you're willing to bend the rules. But the one that was kind of out there and potentially the most alarming was when we had the evidentiary hearing where Cy Ray had testified. This was in one of the motions to compel, about the location data, and seemed to be suggesting quite strongly that there had been, at best, some serious misunderstanding of the location data, and at worst, some intentional misrepresentation of the location data to the grand jury by members of the Moscow Police Department, and that this essentially what had happened was that the FBI had initially received and kind of done most of the processing and analysis of the location data. But when it came time to present it from the grand jury, one of the Moscow Police Department detectives kind of took that on and did it himself. And according to Cy Ray, at least some of what was presented to the grand jury was contradicted by the materials that had come into his possession. So that's kind of what concerns me, is that, this was going to come out at trial. These are going to be impeachable issues, and they're going to be embarrassing. Okay. If you have a detective who's misrepresenting information to the grand jury, that's, that's Frank's stuff. It's Brady stuff. It's not good. Okay. It's not good. And it just kind of comes back to my eternal grievance of, like, why is it so freaking hard to just run a clean investigation? Just run a clean freaking investigation. I don't know why that should be so difficult, but it's like every case we watch, it seems like these days there's some way where the rules have been violated, they've been ignored, they've been disregarded. So I really would have liked assurance that it wasn't that we went ahead and took this plea deal and decided not to have a trial because we didn't want that kind of information coming out. We wanted to protect this officer. We don't want him to have to be on a Brady list. We don't want to be embarrassed by indications that perhaps we're not following the rules. We're just going to present what we want to present, what serves our interests, and forget about integrity and stuff like that. I didn't get that assurance. Now, of course, I'm not saying that is the motivation. I have no idea. I don't know. But it's out there. It's a thing I noticed. It's a thing that concerned me. It's a thing that, again, it would have been nice to have that put to rest, but it wasn't. It wasn't. So we get to the plea process, and oops, what do we have here? Hang on a second. I wanted to bring this up because during the guilty plea hearing, the Judge Hippler, he gives some kind of commentary about his role in dealing with a plea. And so there is a specific process that they have to go through when they're accepting a guilty plea. It's laid out in this rule. So they have to show the plea is voluntary. The defendant's been informed of the consequences. He's been advised that you waive these various rights. He's informed of the nature of the charge, and it has to disclose whether there has been any type of agreement. If there is an agreement, it's got to be clear on the record that the court isn't bound by it. So very routine when you do a guilty plea in court. They do a colloquy with the defendant and literally just go through this stuff on the record, like make sure we've got him saying, yes, it's voluntary. Yes, I've been informed of the consequences, et cetera, et cetera. And that way that kind of takes these issues potentially off the table. But then there's also this rule that deals specifically with the plea agreement procedure. And so essentially, plea agreements, they can be just between the defendant and the prosecuting attorney, and typically they usually are. And they can do all of these different things with it. They can make agreed sentencing recommendations. They can modify the charging. They can ask for alternative dispositions, things like that. But if they're going to do that in Idaho, they have to give notice of it. It has to be disclosed. The court can accept or reject the agreement. The court doesn't have to take a plea. They can say it's not in the interest of justice. And that will happen sometimes if there has been, a drastic reduction in charges that doesn't seem to be supported by the evidence. Maybe there's, some hint of favoritism or, political motives or something like that going on. The judge doesn't have to accept it. They can say, nope, this does not serve the interest of justice. It doesn't happen very often, but it does happen. It's definitely not unheard of. When it involves a sentencing recommendation, again, defendant has to be advised that if I don't follow this recommendation, too bad, so sad. Like that's not something you get to go appeal about. The court is not bound by a plea agreement. Other than, details like charges that are going to be dismissed and things like that. But as far as sentencing goes and what sentence is imposed, you don't get to bind the court. So if they are going to reject the plea agreement, they have to inform the parties of it. Give the defendant the opportunity to withdraw the plea, and advise the defendant that if you want to go forward with the plea, the plea agreement, you might get something worse. Like I'm not bound by it. I can do whatever the law would allow me to do. Some cases, I think this isn't going to be feasible, right? If the deal is that, well, I guess it gets a little bit complicated. It doesn't matter so much in this case, because of course everything got followed at the end of the day. But just that there is a little bit of kind of restriction on the court's ability to differ in opinion from the parties, differ from the resolution that the parties have decided between themselves is appropriate in the case. So with that, guys, let's go ahead and take a look at the plea hearing. So I'm going to go back. I have this queued up in the part where we start taking the plea.
Lift that they've accomplished in preparing for and orchestrating this hearing today, as well as to all the security attendant today that you see, and some of whom many of whom you don't see, with less than 48 hours notice. And so I appreciate the hard work that they've been doing. Frankly, some of them while they were on some vacation prior to the trial starting and had to call that short. And so I appreciate very much their professionalism and dedication. All right. That said, let's move to the business of today. I understand the state and the defense have reached a plea agreement in this case. For the record, I have a written plea agreement which indicates in sum the defendant will plead guilty to all 5 counts in the indictment: burglary, felony, and first-degree murder, 4 counts. The state and the defendant stipulate, that is, that the defense is not free to argue for a lesser sentence at sentencing, to the following. The defendant on the burglary charge will be sentenced to 10 years fixed, and that the defendant on counts 2 through 5, the 4 counts of first-degree homicide, on each count would receive a fixed life sentence, all 5 of those counts to run consecutive to one another. Defendant, as part of the plea agreement, waives his right to appeal, as well as his right to appeal the sentence and his right to seek leniency or reconsideration of the sentence under Idaho Criminal Rule 35. This is not a Rule 11 agreement, meaning the court is not bound by the plea agreement and could impose a different lawful sentence at sentencing. The stipulated agreement between the parties is the maximum on each count. So theoretically, the only thing the court could do would be a lesser sentence at sentencing. But the defendant is not free to ask the court to do so under the plea agreement. Are there any other material terms of the plea agreement that the parties would like to make? Obviously, the plea agreement, the written plea agreement will speak for itself and be part of the court record.
Not from the state, Your Honor. Thank you.
No, Your Honor. Thank you.
All right, very well. All right. Ms.
So that was literally just that part of the rule that says he's got to go over it in court, review it. He just did. Notice has been given, and now we proceed with the business at hand.
Taylor, have you had sufficient time to discuss this case and all of its ramifications with your client?
I have, Your Honor.
Have you discussed fully with him his rights, defenses, and possible consequences to him of the guilty plea?
Yes, Your Honor.
Have you been able to do all the discovery you feel necessary?
Yes, Your Honor.
And have you informed your client of the importance of providing the court truthful and accurate answers in taking this plea today?
I have.
Have you apprised your client of any and all offers and counter offers and answered his questions about those?
Yes.
Do you consent to the entry of the plea today?
I do.
All right, Mr. Kohberger, I need to ask you some questions this afternoon, or I guess it's this morning still. I do this to ensure that you understand, so that I am assured that you understand the nature of the charges to which I understand you're going to plead guilty, as well as the possible consequences to you of your guilty pleas. I want to make sure your plea is given voluntarily, and I want to make sure that you actually committed the crimes to which you're pleading guilty, because I don't want you to plead guilty to a crime you didn't commit. If you attempt to plead guilty today, but for some reason I don't accept your plea, then it is possible that your statements today could be used against you later at trial. Do you understand that?
Yes.
All right. Thank you. And now while you're standing, actually.
I'm just going to pause this and point out that very good indication here that he's been coached, for how to get through this plea agreement, because nobody told him to stand for the court. He seems to be a smart guy, and has probably picked up on the court process and knows that you stand to address the court. But nevertheless, just kind of did it on his own, unprompted. So it suggests to me, he's been fully prepared for what this is going to look like, and what's going to happen here.
Why don't you take the oath from the clerk?
Do you solemnly swear or affirm that the testimony you shall give in the matter not given before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes. All right. And Mr. Kohberger, just to make it easier, you don't need to stand when you speak to me. I appreciate the sign of respect, but for convenience, you can remain seated. All right. Before I start asking you questions today, have you consumed substantive questions? Let me ask you, have you consumed any alcohol, drug, or other intoxicating substance that would impair your ability to understand or exercise reasonable judgment?
No.
You feel like you are thinking clearly today?
Yes.
All right. I want you to understand what the possible penalties are for each of the crimes to which I understand you're going to offer a guilty plea today. They include, on count one, the burglary, a fine of up to $50,000 and a period of incarceration of up to 10 years in the state penitentiary. You may be required to pay restitution to any victims of the crime. Count 2, 3, 4, and 5 for first-degree murder. The consequences include a fine of up to $50,000, a period of incarceration of life imprisonment, which is a requirement of a sentence, that it be a life sentence with a mandatory minimum sentence of at least 10 years on each of those counts. In addition, you would be potentially responsible for a fine of up to $5,000 to each of the victims of your crime, to be enforced in the form of a civil judgment, to operate as additional punishment. This is in excess of any restitution or fines that the court could order.
I want to talk about this just briefly because it comes up with the fine. You're fining somebody that you're just about to put in prison for life. How does this compute? And the reality is that, most of the time, it is a formality. It doesn't mean anything at all. It's never going to be paid. If you qualify for work in prison, you're typically, getting like 10 cents an hour or something like that. You're getting wages for like working in the the prison kitchen or something like that. Lots of different jobs available, but you're not going to be making a fortune in there. So the concern really is, does he have assets, that could be hiding somewhere, come into possession of assets? Let's say, for example, he gets an inheritance. His parents pass, he gets an inheritance. He's got this mass bulk of money now. That's typically the type of thing it's aimed at. He's not going to be able to, spend it all on commissary. There are typically protections for like how much money can be taken out of somebody's funds, prison funds, for what we call legal financial obligations. So they may not be able to take all of it, but they can, take a pretty good sum of it to pay off your fines. And that does typically happen automatically. So that's what it's going after. It's going after commissary.
And again, you may be required to pay restitution to the victims of the crime. You would be required to provide, as to counts 1, 2, 3, 4, and 5, a DNA sample and a right thumbprint impression, and potentially pay for analysis of those samples. You would lose any right to possess, purchase, or carry a firearm, the right to serve on jury duty, the right to hold public office, and the right to vote. Do you understand the charges and all those possible consequences?
Yes.
You've heard the plea agreement that I talked about today. Do you agree with that plea agreement?
Yes.
And do you understand the nature of the charges that you've been charged with that I understand you're going to plead guilty today to?
Yes.
As as I indicated, I'm not bound by the plea agreement, but the plea agreement is for the maximum on each count. Do you understand that I'm not bound by the plea agreement?
Yes.
Has anyone promised you that I would be lenient or easy on you if you pled guilty?
No.
Has anyone threatened you or anyone close to you to get you to plead guilty?
No.
Has anyone other than the state's agreements with respect to the plea agreement, has anyone promised you anything in exchange for your plea agreement?
No.
Has anyone told you to be untruthful in answering my questions today?
No.
Has anyone offered you a reward of any kind other than the plea agreement in order to get you to plead guilty today?
No.
Are you pleading guilty because you are guilty?
Yes.
And that's kind of the key right there. Okay. That's really the key to this whole plea hearing. As soon as I heard that, this is definitely not an Anders plea, guys. This is not an Anders plea. This is not maintaining innocence. Literally just said he's pleading guilty because he is guilty. Okay. Now, I know plenty of people plead guilty without being guilty. Okay, for a whole variety of reasons. But again, looking through the circumstances of all of this, nothing on the face of the plea agreement says you can't do an Anders plea if you want to. You can't continue to maintain your innocence and still do the guilty plea. But that isn't what he did. That isn't what he did. I want to take a minute here to acknowledge Ann Taylor and the work that she's done in this case, because as I think is fairly normal and routine, the person who sits next to the bad guy in court just gets absolutely shit on. Like it's just normal, awful person. How can you do that? Et cetera, et cetera. And I want to offer a perspective here, which is that, yes, Bryan Kohberger, he's a PhD criminology student. He's probably a little bit more educated about the system than, your average lay person, but he's definitely not a lawyer. And I don't have any reason to suspect he knows a lot about the ins and outs of, types of pleas and things like that, the distinction between an Anders plea and a straight plea and so forth. So to the extent this is an admission of guilt, which facially it is. This is. She made that happen. Okay. Think about that. She made that happen. They had all of the legal maneuvering room in the world for him to say, no, I'm innocent, but I want to take advantage of the plea agreement. The plea agreement doesn't say he can't do that. And the U.S. Supreme Court precedent allows him to do that. So I just encourage anybody who, has that dim view of defense lawyers to just give that some consideration. She made that happen.
And counsel, obviously there have been a number of motions filed to suppress evidence in this case. Other than those filed, are there any other motions that you felt were available with respect to Rule 12?
No, Your Honor.
And Mr. Kohberger, you understand that by entering the guilty plea in this case, you would be giving up your right to appeal any decision this court made, as well as your sentence.
Yes.
Have you had enough time to decide whether or not to plead guilty?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
Given your choices, do you believe it's in your best interest to plead guilty?
Yes.
Have you discussed fully the matter of pleading guilty with your attorney, and are you satisfied with the advice you've received?
Yes.
Has your attorney advised you to your satisfaction about what your rights are, what your defenses may be, and what the possible consequences to you of your guilty plea are?
Yes.
Has your attorney done everything you've asked them to do?
Yes.
Are you satisfied with their representation of you?
Yes.
I want to pause here again because I just want to emphasize how difficult it can be to be in this situation. Okay. When we kind of rewind this case a year and a half, maybe 2 years now, I can't even remember when it was the first time that they stood up in court and said, we firmly believe that Bryan Kohberger is innocent. We firmly believe he didn't commit these crimes. The defense lawyers weren't there. They are relying on what they have in the evidence that's been presented to them in discovery and what they've been told by their client. Now, every defense lawyer who's been doing this for a while knows what your client tells you. It's a piece of information, but it's not one you stick your neck out on, okay? Because just often, criminality and lying, they can really kind of go hand in hand. You would be very foolish to, stake your credibility with the court and so forth, just on something that your client has told you. And so I know that since this guilty plea came down, a lot of people have wondered about that when she said that, did she mean it? Did something change? We're never going to know. Okay. First off, she's never going to tell us, unless Bryan Kohberger himself decides to tell us kind of the story of how this case went. We're never going to know. From a timeline standpoint, what it kind of looks like to me is that, they got a thin case in the probable cause affidavit. It's enough to charge, but it was a thin case. And everybody expected, like we've said a million times, the bulk of the investigation was going to take place after the arrest. Once they got a hold of his car, once they got a hold of his devices, all of his computers, can go through all of that information. That's where we expected the case to be made. And then lo and behold, that really didn't happen. It didn't happen. It didn't produce a lot of information. So I can definitely see a situation where, your client's telling you, hey, I'm innocent. You're getting the discovery in. The discovery is not producing the type of evidence that you would expect to see if he was in fact guilty. You would be expecting to see, the DNA. You'd expect to find blood. You'd expect to find hair, other types of trace evidence, things like that, especially just given the nature of this crime. You would expect to have location data. You'd expect to have, some type of, social media connection or personal connection, or they had, met here or there. Maybe there's a receipt for the Mad Greek, all of these types of things to just kind of incrementally build the case. And it really looks like that was not happening. And certainly from what we learned from the press conference that they held after the sentencing, no, they never did. They never did get anything like that. They emphasized never were able to find any kind of connection between Bryan Kohberger and any of the victims. Not on social media, not in real life, not anywhere. And they looked at it from all angles. They also made that clear. There was some indication that he had wiped his his computer, his phones. He would use this. He used a VPN, and he would use what they described as like partial wiping software or something like that to try to clear his history. But that's not the only source of the information. They can look at it from the victim's ends as well. They can look at it from the server end of things. Never found anything like that. So I can absolutely understand. I can put myself in the shoes of that attorney seeing these accusations, seeing what evidence they have, but really seeing what evidence they don't have. Thinking, yeah, you know, I don't know about this case. I really don't. But then sometimes something comes out they didn't anticipate. Sometimes they get caught in a lie. I'm sure I've told this story before about a case that I had where a couple was awoken late at night and the sound of somebody down at their door, apparently trying to get in their door. So they go downstairs. The husband goes downstairs. He has a gun, brings the gun. The intruder at this point has moved around to the back door and is rattling at the back door, trying to get into the back door. I think manages to get the back door open, is then, promptly, faced with a shotgun and leaves, runs away. So the homeowners called the police. Police arrived. This is like in the middle of winter. It's like February or something like that. And there's very little that they have to go on. They don't have much of a description. There's no like real evidence. Guy never came inside. There's no cameras, nothing like that. A few hours later, my client is kind of walking down the street, generally in the neighborhood. As far as I can tell, he's like the only person out in the neighborhood at that time. Police stop him and ultimately arrest him for, being the alleged intruder. Well, client swears up and down, it's not me. I'm a normal guy. I'm going to school. I'm managing this restaurant over here. I was at a friend's house at a party, and it was just late, and I was walking home because I was, I'd been drinking. I didn't want to drive, so I'd left my car and I was walking. But it seems plausible, seems credible. Don't really have any reason to suspect that until several weeks later, I get a supplemental police report because you see there had been some snow on the ground, and in the intervening weeks, the snow had melted. And lo and behold, on the back porch where the intruder had been confronted, they find a cell phone, and they turn the cell phone over to the police. The police get into the cell phone. And who do you think it belongs to? Who do you think that cell phone belongs to? So I remember having a little sit down about that. Yeah, so we're going to have to deal with this police report. And the response at that point was to find out if the plea offer was still on the table. So those kinds of things happen fairly routinely. Now, no idea, of course, if anything like that happened in this case. We don't know if she even thinks he is guilty, or if she just thought really strong probability he's going to be convicted at trial, given this evidence. It's in his interest. But, if you thought that, you'd tell him about the Andrews plea. You'd encourage him to go that direction. And the main reason why you would encourage him to go that direction is because if you don't go in that direction, guys, you take pretty much all post-conviction relief off the table. You pretty much take it off the table. Because no matter what kind of error you can point at, you can discover all kinds of shenanigans, all kinds of new evidence, and so forth. But the standard on post-conviction relief is so high. It's typically something like a manifest injustice type of standard, very difficult to meet. It's like harmless error kind of on steroids. And the reviewing court is always going to look at it and be like, yeah, wow, this looks really bad. And maybe this was a terrible, egregious violation of your rights, but it's harmless because you stood up in court and said you did it. The admission of guilt Not 100% forecloses post-conviction relief, but to a massive degree, it does. It does. So the reason why I'm pausing here is because there's such an opportunity for conflict when a case develops in this way. You've been led to expect innocence, you're seeing innocence, you find, something that's inconsistent with that. You got to be able to work with a client who is almost certainly characterized by denial. Okay? We already know, and this is just, yes, innocent people get charged, innocent people get convicted, but that's not the bulk of the criminal justice system. The bulk of the criminal justice system is victimization, and they typically are getting the right people. And the arguments around are typically around the edges. They're about things like, is this the right crime that is being charged? Are there others that should bear greater accountability? Is there sentencing? Is there alternative sentencing that might be appropriate and called for in this type of case? That is what probably 95 to 98% of defense lawyering is. Okay, it's around those edges. And it's just trying to make sure, the client's being fairly treated, process is working the way that it's supposed to work. So, most of the time they got it right. But when you're dealing with somebody who's going to sit there at the table with you, guys, and this has literally happened to me. We are watching a video of you committing the crime, and you're trying to tell me that's not you, while we're both staring at the same very distinctive tattoo that you have right here in front of me and right there on that video. Denial is what characterizes criminals, by and large. Like, if I were going to pick one characteristic, it's denial. So I remember having a conversation with a prosecutor once. It was one of those, how do you do your job, types of philosophical conversations. And I said, well, big part of my job is just the compassionate engagement of denial. And everybody's going to have their ways and their strategies to be able to do that. I want to give her credit, because this is the point. This is the opportunity for the attorney-client relationship to really blow up. If we're at a point where we got to have hard conversations about the evidence, we got to have hard conversations about what a jury is likely to think about that. When I would talk to clients about plea deals, a case, take a case where the clients insist they're innocent. I've got the reports, I've done the investigation, I've done the interviews. They're clearly not. They're going to get convicted. I never found it particularly useful to talk about what I think. It doesn't matter. What I think is really irrelevant. So I would typically talk to people just in terms of, well, but here's what a jury is likely to think about something, and I just found that would work, because that would allow me to not be the enemy, while still, pointing out kind of the obvious here, which is you're going to be convicted. Like, you are guilty, you're going to get convicted. But it also just gave them a little bit of space, not have to challenge the ego so much. I'm not a priest. I'm not here to make you confess. We're trying to work in your best interests and get the best outcome for you. Your conscience is between you and your God, if you have one. but not, not everybody really develops that skill very well. And so you can easily get in a situation where, I really think you should take the plea. Defendant gets all huffy about that. You think I'm guilty. You're not working for me. You don't want to go to trial, yada, yada. It can rapidly devolve into a conflict of interest where now, look, sorry, I got to get out of the case. You need to get somebody else to come in and clean up this mess. Didn't happen here. Okay. Didn't happen here. She got him to admit guilt. Guys, I cannot overstate the significance of that. And just, I would love to be a fly on a wall. I would love to see her manner of dealing with her clients, because I got to tell you, I'm extremely impressed that she was able to pull that off. Okay, that was very much a service to the court, to the system, to the people of Idaho, to the victims in this case. I will repeat, she made that happen, because Anders' plea, freely available. It's on the table. It's her obligation to discuss that with them. She got him to admit guilt. She got him to admit guilt and still be happy with her about it. Extremely impressive lawyering to me.
I have received a written guilty plea advisory questionnaire that is purported to be filled out by you. Did you fill that document out?
Yes.
Did you understand the questions that you answered in this document?
Yes.
And are the answers that are outlined in this document your answers?
Yes.
Are those answers truthful?
Yes.
Did you sign the document?
Yes.
And this document outlines many of the rights that you have in this case should you not plead guilty. Did you understand those rights?
Yes.
They include a right to a jury trial. Do you understand that?
Yes.
They include a right to the presumption of innocence. Do you understand that?
Yes.
They have the right to require the state to prove your guilt as to each element beyond a reasonable doubt. Do you understand that?
Yes.
They include a right to confront your accusers and cross-examine witnesses presented by the state, including by utilizing the subpoena power of the court to accomplish that. Do you understand that?
Yes.
You understand you would have a privilege against self-incrimination and a right to remain silent, meaning you would not be compelled to testify if you did not wish to, had you not pled guilty.
Yes.
You understand you're giving up that privilege and those rights that I've just outlined by pleading guilty.
Yes.
All right, I want you to understand what the state would have had to have proven at trial had you, as to the crimes that you're pleading guilty to, had you, if you didn't plead guilty. Let me find the document. Hang on a second here. All right. So as to count one burglary, the state would have to have proven that on or about November 13, 2022 in Latah County, Idaho, you unlawfully entered a residence located at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder. As to count two, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Madison Mogen, a human being, by stabbing Madison Mogen, from which she died. As to count 3, the state would have had to have proven that on that same date in Latah County at that same address, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Kaylee Goncalves, a human being, by stabbing her, from which she died. As to count 4, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Xana Kernodle, a human being, by stabbing her, from which she died. And then as to count 5, also murder in the first degree, that on or about November 13th, 2022, in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Ethan Chapin, a human being, by stabbing him, from which he died. Do you understand those things the state would have had to have proven?
Yes.
And do you understand that by pleading guilty, the state no longer has to prove those things because you're admitting those things are true?
Yes.
So that was, again, just repeat, underscore. He is saying that's true, that he did that.
I want to also make, for the record, the defendant has provided with the guilty plea advisory form a document entitled Written Factual Basis that purports to have the defendant's signature dated 1 July 2025. Did you sign that document?
Yes.
And did you agree with the written factual basis that is included there?
Yes.
And then let me ask you, did you, on November 13th, 2022, enter the residence at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder?
Yes.
Did you, on November 13th, 2022, in Latah County, state of Idaho, kill and murder Madison Mogen, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice aforethought?
Yes.
Did you, on or about that same date in Moscow, Idaho, kill and murder Kaylee Goncalves, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice aforethought?
Yes.
And did you, on that same date in Moscow, Idaho, kill and murder Xana Kernodle, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, with premeditation and malice aforethought?
Yes.
And then on or about November 13th, 2022, again in Latah County, Idaho, did you kill and murder Ethan Chapin, a human being?
Yes.
Did you do that willfully, unlawfully, deliberately, with premeditation and malice aforethought?
Yes.
I would ask the state at this time to provide its recitation of its factual basis had this case gone to trial.
Thank you, Your Honor. Your Honor, the organization of the recitation is different than what I think the court and the public may be familiar with from the probable cause affidavit and other documents. The state's evidence as an overview would show that back in March of 2022, when the defendant was residing in his parents' residence or was residing back in.
I'm just going to pause this real briefly because this read to me when Mr. Thompson was reading a statement. This was basically his opening statement that he had prepared for trial or was in the process of preparing for trial. There's been so much, like, since day one when the probable cause affidavit came out, kind of from my perspective, lack of clarity about those documents, what they contain, and, is it exhaustive? A lot of kind of I don't know, reasoning that, well, probable cause is a low standard, and so you just put, enough in the probable cause affidavit to support the charge, and there would be all kinds of evidence that isn't in the probable cause affidavit that we wouldn't know about until trial. That's why the PC affidavit is so thin. I've been saying since day one that's absolute nonsense. That's not how it works. The probable cause affidavit is where you lay out the broad outlines of your case and the basis for the charge against them. There's a whole bunch of reasons for doing that. Not leaving things out of the picture. Omissions, particularly material omissions, can be very problematic from a legal standpoint. We've heard about Franks, if you followed us in the Delphi case. They brought a Franks motion here as well. Didn't really, wasn't as exciting as the one in Delphi, I guess, so it didn't get quite as much attention. But that's a U.S. Supreme Court case, Delaware versus Franks, that basically says if there's an omission of material information that could change the calculation of whether there's probable cause or not here, then you have to kind of reevaluate the basis for probable cause. If there's false information in it, you may need to excise that out. So there's let's say you have a probable cause affidavit, and it turns out that some of the evidence that you relied upon is, I don't know, it's invalid, or maybe you were mistaken. You thought it was something and it went to the lab and it turns out that you were wrong. So that gets, in essence, excised from the probable cause calculation. Well, then what are you left with? You're left with whatever else you put in the affidavit. So you put everything in the affidavit to make sure, hey, if we lose some of this, we still got all this other. You do not just selectively put in little bits and pieces to try to support that determination. This, I think, is a pretty similar type of situation. The factual basis for the plea, you're not gonna leave stuff out. You're gonna go ahead and disclose what it is that you know, what it is that you anticipated you were going to be able to prove at trial. That's the whole legal justification for being able to enter a plea at all. You don't. You have to have a factual basis for a plea. Because you don't want people pleading guilty to, like, for example, crimes that didn't happen. So this is also kind of a due process requirement that goes back to some old Supreme Court authority. So what we are about to hear is what I anticipate is the case they were going to put on at trial. It's not going to be every detail, but it's going to be the broad outlines of it.
Pennsylvania, his home state. He purchased online a K-bar knife and sheath with an Amazon gift card that he had purchased shortly prior to the purchase of the knife, sheath, and sharpener. Jumping ahead, the end of June of that year, the defendant, Mr. Kohberger, moved from Pennsylvania to Pullman, Washington, which is right across the state line from Moscow, Idaho, for the purpose of pursuing a PhD in criminal justice at Washington State University. The state's evidence would indicate that beginning July 9th of 2022, Mr. Kohberger's phone began connecting to a cell tower that serves the area of the 1122 King Road residence in Moscow, Idaho. Now, I will acknowledge for the court and all present that there are many residences in that area. It's a dense population of mostly college-related occupants. Between July 9th of 2022 and November 7th, the defendant's phone connected to that particular tower during late night, early morning hours, 10 p.m. to 4 a.m. on approximately 23 times.
I want to pause this because this has been like such a big issue in the case. Again, the location and so forth. He's talking about the cell tower connection. Okay, and this goes all the way back to day one and the probable cause affidavit and the concerns I had when I read it about that is not precise location data. Okay, if you're just talking about connecting to a tower, you can be talking about a range of 10 miles, 20 miles. I mean, you can be talking about an extremely large area that a person is in. They did so much so much investigation and discovery in this case that I would find it really hard to believe they didn't geofence. Geofence is very different. It's going to Google and it's looking at location information and stuff like that. GPS-based data for the most part. Much more precise than a connection to a single tower. We had also heard through the pretrial litigation process that there may or may not have been timing advance records that were obtained. Timing advance records can help them narrow down where in the range of the cell tower you are, because what it does is it measures the time that it takes for the signal to pass between your phone and the tower. And so based on that, you can get a distance measurement. Still won't put you in an exact location, but it can give you a radius from the tower that is going to be narrower than just you were anywhere within the range of that particular tower. So I noticed this right away when he said this in the statement. They were still going to rely on just this tower data. And of course, we've had the big document dump that came out from Moscow Police Department after the sentencing hearing with a lot of the investigative reports and things like that. It's a massive amount of information. I've started going through it. Lots of people have started going through it. Haven't seen anything at all yet about location data. And frankly, we might not, because that seems to have been kind of primarily handled by the FBI and the CAS team. And they are very unlikely to do what the Moscow Police Department has done and just go ahead and make their files public. But that just, continued to raise questions for me about how good their information really was and what kind of inferences they wanted the jury to be able to derive from it. If there was geofence data, for example, sought out, was his phone in it? If it was, I would have expected them to be mentioning this in the statement of facts. I would have expected it maybe to come up in pretrial hearings or something like that. Some type of more precise location data than just a tower. I would expect to hear that. And if not, maybe there's an explanation for it. If you turn off location services on your phone, it's going to really limit the type of location data that they might be able to get through a geofence warrant. So just kind of an example of a lot of the questions that I think are still out there that would have been nice to have been fleshed out in a trial to get some clearer answers. Did he in fact stake out this house? That's clearly the implication from this line of argument. But the evidence that he's offering in support of that inference it's not strong support for that inference. It's not precise. It really just tells you he went to Moscow a bunch of times. And if you're familiar with this area, Moscow is right there. It's right across the border. One of the most common reasons that you would go there is because gas is massively cheaper in Idaho than it is in Washington. And so if you can drive 5 minutes and pay like 80 cents a gallon less, lots of people will do that. There's also no sales tax in Idaho. So it's, you might go do your grocery shopping, buy your clothes, things like that. So lots of reasons to cross the border, just for casual personal reasons. This is where a trial would have been really nice to be able to flesh out. What does this actually tell us? Okay, connected to a cell tower. What does that actually tell us? I know you want us to think it means he was staking out the house or something like that, but your evidence is not strong enough to lead to that inference. Something like GPS data might be, but just you were in tower range doesn't get me there.
Now, I will acknowledge also, we do not have evidence that the defendant had direct contact with 1122 or with residents of 1122, but we can put his phone in that area on those times. In the interim, on August 22nd of 2022, Lake Tahoe County Sheriff's Deputy Darren Duke conducted a traffic stop in the early morning hour or late evening hours, about 11 p.m. on the west side of Moscow, on the Moscow-Pullman Road. This was a traffic stop of Mr. Kohberger's car, which turned out to be a 2015 white Hyundai Elantra with Pennsylvania plates. During the course of the traffic stop, Deputy Duke was able to obtain Mr. Kohberger's name, Bryan Kohberger, his phone number, and his address, which at that point was an apartment address in Pullman. We then move to the early morning hours of November 13th, 2022. The state's evidence would show that early morning hours on that day, Mr. Kohberger's phone left his Pullman residence, which is an apartment in kind of the central northwest part of Pullman. That phone was then subsequently turned off at approximately 2:54 a.m. and remained off until approximately 4:48 a.m. on Sunday, the 13th of November. On Sunday, the state's...
Oops. Yikes. Sorry about that, guys. Let me get back to where we were. I think I was trying to check the echo and see if that was...
which is an apartment in kind of the north...
if that was something on this end. Okay. I've got it back up. Let's go.
Central northwest part of Pullman. That phone was then subsequently turned off at approximately 2:54 a.m. and remained off until approximately 4:48 a.m. on Sunday, the 13th of November. On Sunday, the state's evidence would include a trial, video surveillance of a business on the Moscow-Pullman Highway, just across the state line from Moscow. It would show a vehicle matching the description of the defendant's Hyundai Elantra, entering Moscow at approximately 3:02 a.m. Compiled surveillance that the investigators put together from businesses and residents then show the defendant's car, the white Elantra, as I've described, circling the 1122 King Road area, that neighborhood, starting around 3:30 or so in the morning. Comes into the immediate area of 1122 King Road, which is actually on a dead end, and then leaves several times. And approximately 4:05 that morning, the defense car had entered that area, was leaving, stopped at the intersection of King and Queen Road, did a U-turn, and the state's evidence would show that the defendant's car came back and parked behind and above the 1122 King Road residence. The state believes that its evidence would then show that the defendant entered the residence of 1122 through the kitchen sliding door on the back side of the residence, which is the side of the residence that would face the area above where the defendant's car was parked. The defendant entered the residence, went to the third floor, and with a knife, killed Madison Mogen and Kaylee Goncalves. The defendant, as he left that room, for whatever reason, ended up leaving, or the sheath for a K-bar knife was left on the bed next to Madison Mogen's body. And I can jump ahead. That sheath was tested by the Idaho State Police Forensic Lab, and single source male DNA was found on the snap of that sheath, as well as blood from both Kaylee and Madison and other trace evidence. But it's important to note single source male DNA was on the snap of that sheath. The state's evidence would show that Xana Kernodle was still awake at this time. In fact, had taken a DoorDash order not long before this started. Her room was not on the third floor. It was on the second floor on the west side. As the defendant was either coming down the stairs or leaving, he encountered Xana, and he ended up killing her, also with a large knife. Ethan Chapin, Xana's boyfriend, was asleep in their bedroom, in her bedroom, and the defendant killed him as well with a large fixed blade knife. Each victim suffered multiple wounds. I will state for the record that there is no evidence there was any sexual component or sexual assault on any of the victims. I want to make that clear so there's no speculation. There were two other roommates in the house, and they were already asleep. During the course of this, one of those roommates awoke, looked out her door not knowing what was going on, and saw the defendant, who was dressed in black with a black balaclava on, holding some sort of container in his hand. And she saw him leave the house through the direction of the kitchen where that sliding door is that I mentioned before. At approximately 4:20 that morning, so this would have been 15 minutes or so later, the defendant's car is seen on a surveillance camera for 1112 King Road, which is immediately next door to the west of 1122, leaving the area at a high rate of speed. And if the court were to see that, or anybody in this courtroom would see that, you can see the car almost loses control as it makes the corner, heads north, and then turns to go south on Walenta, which is one of the only ways to get out of that part of town. The evidence would show that following that, the defendant in his Elantra drove south of Moscow. We know that he drove on the back roads because there are surveillance cameras on the main highways, Highway 95, that would have picked up the defendant's car if he'd gone that route. And they did not show the defendant's car on that route during the time. So we know that he went through a variety of back roads in very rural, isolated part of Latah County. About 4:48 that morning, the defendant's phone comes back on. And the evidence will show that that phone was located south of Moscow, likely at a side road intersection with Highway 95. From there, the defendant's phone activity tracks it heading back north towards Pullman, Washington, where the defendant lived. About 5:26, starting approximately 5:26, various surveillance cameras in Pullman, Washington pick up the defendant's vehicle as he enters Pullman from the south and heads north and slightly west towards his apartment, where he arrived at approximately 5:30 in the morning. Later that morning, Sunday, the 13th of November of 2022, Mr. Kohberger's phone returned to the area of King Road. We don't know exactly what he did, but it returned to that area. It's about 9 o'clock in the morning. He was there for about 10 minutes and then returned to his Pullman residence. About 9:30, the state's evidence will show, evidence taken from the defendant's phone, that he took a selfie of himself on his phone in what appears to be the bathroom of his Pullman apartment with a thumbs up. The defendant's phone then went to the Lewiston Clarkston Valley, approximately 30 miles south of Moscow and Pullman. And the defendant is actually seen with his car at various businesses down there. This area is the confluence of the Clearwater River and the Snake River. Lewiston is Idaho's seaport. Large bodies of moving water down there. In addition to tracing the defendant's activities, as I've just outlined, on the 13th and leading up to the 13th, the state's evidence will show that following Sunday, November 13th of 2022, business records show that the defendant began searching for a K-bar knife and a K-bar knife sheath, as the state believes, to replace the one that was left at the scene of the murders. The evidence also will suggest that there were at least attempts by the defendant to delete or alter his purchase history on Amazon, where all these transactions had occurred. Later that week, the state's evidence will show that Mr. Kohberger went to what we would call DMV, motor vehicle licensing here in Idaho, in Pullman, to change his car registration from Pennsylvania to Washington. That's of note because Pennsylvania cars do not require a front license plate. The vehicles seen on the surveillance cameras of the defendant's car showed it didn't have a front license plate on it. At the time of the traffic stop by Deputy Duke in August, it was Pennsylvania plate, no front license plate. Mr. Kohberger proceeded to finish his semester of studies at Washington State University and returned to Pennsylvania for the holidays. Law enforcement at this point were aware of Mr. Kohberger, had been accessing information about him, were trying to find him. They located him in Pennsylvania, and they conducted what's called a trash pull. During the nighttime hours, agents of the FBI, who assisted immensely with this case, working with the sanitation department back in this neighborhood in Pennsylvania, took trash that had been set out on the street for collection, sent the contents of that from the Pennsylvania residence of the defendant's parents to the Idaho State Forensic Laboratory, where the lab experts there were able to identify DNA on a Q-tip as coming from the father of the person whose DNA was found on the knife sheath that was next to Madison Mogen's body in the bed. Subsequently, an arrest warrant was issued here in Idaho, and a search warrant was issued in the state of Pennsylvania with the assistance not only of the FBI, but the Pennsylvania State Police. Mr. Kohberger was arrested at his parents' home to return to Idaho. Upon his return to Idaho, a DNA sample was taken from him, and it matched the DNA found on the knife sheath next to Maddie's body at the crime scene. I can tell the court, in public, the weapon itself, the knife, has not yet been recovered. I can tell the court that the defendant's apartment in Pullman was searched, as well as his office. Spartan would be a kind characterization. There was virtually nothing there. Nothing of evidentiary value was found. And of course, we're now talking 6-8 weeks after the time of the killings. In Pennsylvania, the defendant's car was seized, and it was actually pretty much disassembled internally. And it also had been cleaned. There was a bucket of cleaner right beside it. I think we can all look to our own cars, you know, in those compartments in the doors. We try to keep them clean where you put stuff. There's always some degree of crud in there. They were spotless. The defendant's car had been meticulously cleaned inside.
Okay, I just have to pause that right there because clearly Bill Thompson has never ridden in a car belonging to a Mexican. Okay, no, not everybody's car has crud in the cup holder. Some people do actually like clean and detail their cars pretty regularly. Anyway.
And the state would present to the jury that that was part of the defendant's plan in covering up this. The defendant has studied crime. In fact, he did a detailed paper on crime scene processing when he was working on his pre-doctorate degrees, and he had that knowledge and skill. So, Your Honor, at the end, the state submits that the evidence that I've given just a quick overview of and that to present in court would consume weeks, which the state is prepared to do and has been prepared to do, would show that as the defendant has just admitted and pleaded guilty on November 13th, 2022, Ms. Kohberger entered the residence at 1122 King Road in Moscow, Idaho. He did that with the intent to kill. We will not represent that he intended to commit all of the murders that he did that night, but we know that that is what resulted, and that he then killed intentionally, willfully, deliberately, with premeditation, and with malice forethought, Madison Mogen, Kaylee Goncalves, Ethan Chapin, and Xana Kernodle. Thank you.
Thank you.
And so at the end of the day, the statement of facts in support of the plea is essentially the probable cause affidavit with the addition of the information about the Amazon purchase, the search, the attempted deletion of the search history, and then also, you know, he'd apparently cleaned his car. Now, I made videos about this already. I've talked about this. To me, that's not a particularly satisfactory explanation for you know, the lack of transfer DNA or something like that in the car, just because of, you know, this was a very bloody crime. It's hard for me to just imagine a scenario where the perpetrator isn't going to be completely covered in that, and that there isn't going to be some sign of it. So, nevertheless, however, whatever questions remain, that's what we get from the state. And so, still a lot of questions that I think we've had from the outset that are still not answered, because he doesn't, of course, talk about the evidence that they didn't get. For example, they talk about, he reconnected to the King Road tower the following day. Well, then why isn't he on the cameras that you caught the vehicle on, the night before? The vehicle, like the changing the vehicle registration, is just another one. Like, to me, it's such a weak inference, because how on earth would he know that you were looking at a surveillance video of a car that doesn't have a front license plate? That to me is, I'm sure there's some kind of name for like that type of bias, where like you have information that you kind of assume everybody else has, and that they would act as if they had that information, but he didn't have that information. He didn't know. How would that motivate him? So, it remains, from my perspective, a very thin case with a lot of questions still unanswered. Big questions about, certainly, how did he do this? How did one person do this in the time period that's being, being provided? No noise. Why were the surviving roommates allowed to live? Why? Again, we have apparently both the smartest and the dumbest criminal mastermind in history, smart enough to not be able to, transfer any DNA at all, except for the 250 cells or whatever it was on the knife sheath, but yet brings, his phone and his car, to a crime scene. Oh, it sure would have been nice to know more. How does somebody who apparently has never seen these people know them? How does he pick this house? How does he know? How does he know how to go in? How does he know who's where? How does he know how to get out? Why this house in the first place? It just, none of this has been answered. None of this has been answered, and I think that's unfortunate.
All right. Based on the state's proffer, and importantly, based upon defendant's explicit admission to committing these crimes, the court finds there is a factual basis. Therefore, with respect to count 1, burglary, felony, how do you plead, Mr. Kohberger, guilty or not guilty?
Guilty.
As to count 2, murder in the first degree, as it relates to the murder of Madison Mogen, how do you plead, guilty or not guilty?
Guilty.
As to count 3, as it relates to murder in the first degree for the murder of Kaylee Goncalves, how do you plead, guilty or not guilty?
Guilty.
As to count 4, the first degree murder of Xana Kernodle, a human being, how do you plead, guilty or not guilty?
Guilty.
As to count 5, the first degree murder of Ethan Chapin, a human being, how do you plead, guilty or not guilty?
Guilty.
Right. The court will find that the defendant understands the nature of the charges and each offense and the possible consequences to him of his guilty plea. The court finds that there is a factual basis for the plea, and finds the defendant believes the plea to be in his best interest. I find that the plea was given freely, voluntarily, and was intelligently made. I accept the plea. I direct that it be entered. I'll continue the matter for sentencing in this case. I think it was mentioned on the call Monday afternoon, the defense wishes to waive a pretrial investigation. Is that accurate?
Yes, Your Honor.
The state also?
Yes, Your Honor, the state does not believe pre-sentence investigation is needed given the evidence that is available. We want to, though, make sure that all of the victims have the opportunity to make statements to the court at sentencing.
Okay, so this is the last thing I'm going to have us watch here. I mean, it's almost at the end of the hearing anyway, but this was another thing that now sort of jumped out at me. This is a little bit weird. No pre-sentence investigation. Okay, so let's look at that, what that is, guys. Pre-sentence investigation. So this is fairly typical. Again, many, if not most states are going to have some type of process like this, where once you're convicted, somebody goes through and does what's essentially like a background check on you. They're trying to get a sense of what's the appropriate sentence. Are you amenable to some kind of alternative sentence? Should you get, probation? Should you get treatment? All these different kinds of considerations that are going to factor into that. And so they're looking at things like, what's your life history? Do you have other, like, a extended criminal history that suggests, you're not going to be amenable to rehabilitation, things like that. Now, he's getting 4 life sentences, so I can kind of understand it from that perspective. It doesn't really matter that much. But the reason why I think it matters is because what is typically in the pre-sentence investigation, it can, again, be helpful for answering some of these kinds of questions. So it's supposed to include description of the act, including the defendant's version of the criminal act and the defendant's explanation for the act. Guys, as part of the pre-sentence investigation, you interview the defendant. The defendant is interviewed. So now, in cases where the defendant is going to appeal, it's common for them to decline to participate in that. He's waived his right to appeal, and he said, I did it. He said, I did it. You can go interview him through this process. Why on earth would you decline to do that? Any prior criminal record, defendant's social history, interests, activities, etc. They want to know, who is this person? Educational background, employment background, residence history, financial status, health. The defendant's sense of values and outlook on life in general. This kind of goes to, why? Why did this happen? Is the rest of the community at risk? A lot of speculation about Bryan Kohberger and just kind of assumptions, I think, about his psychological status, mental health, etc. He's a psychopath. He's this, he's that. From what we know of his psychological evaluation, he is not a psychopath. At least didn't test as one. I've said before, from my kind of personal experience in court, he does not present as a psychopath. He's far too agreeable. Psychopaths are typically not agreeable at all. They're troublemakers. He doesn't have the type of background that indicates psychopathy. In fact, I'm pretty sure to even diagnose antisocial personality disorder, you might have to have, or maybe it's one of the criteria that doesn't have to be met, but it's in there that, you have basically a history of, disregard for rules and laws and so forth. Like, typically psychopaths, they start getting into trouble real young. It's a chronic problem. He doesn't have that type of history. No, I understand the perspective that, the focus shouldn't be on Bryan Kohberger. The focus should be on the victims and so forth. And I certainly understand that. But there is a social interest in understanding more about crime and its causes. If we want to prevent crime, don't we need to understand what causes it and why and how? And how somebody from apparently a pretty normal background, pretty normal family, would come to be involved in something like this. That's what the pre-sentence investigation report is focused on. Why on earth are we waiving this? Yeah, mental health evaluation. Guys, they can do a mental health evaluation, including, these are reports that are prepared specifically for sentencing, but you can't consider ones that have to do with competency. There was never a competency evaluation in this case, so they can do mental health evaluations and consider that. And ultimately, at the end of the day, you get an opinion from the pre-sentence investigator about, is this person remorseful? Does this person understand? Is this person, dangerous in the future? And so forth. Now, I think an important qualification in all of this is that these are confidential in Idaho. So availability of pre-sentence report to third parties only with the permission of the sentencing judge, and it's only to people with a legitimate professional interest in the information likely to be contained in it. So this is usually going to be DOC, it's going to be treatment providers, people like that, parole board, so something like that. Gives an example: psychiatrist examining facility, correctional institution, private or public rehabilitation program, etc. So maybe this is the thought. It's never going to be made public. It's not for our benefit anyway. It's for the benefit of the court. So why bother? I just have a hard time seeing how more information would not be better in this case. How would more information not be better? Find it really difficult to wrap my head around that. So we're going to move on now to look at the sentencing hearing. So guys, we're not going to watch the whole sentencing hearing. It's out there, it's available on like a gazillion different channels. So plenty of places you can watch it. The bulk of it is the victim impact statements. That's really what I'm going to talk about, is victim impact statements and kind of what they are and why we do them. Because there was some controversy, about some of them. We are going to watch one. We're going to watch my favorite, Kim Cheeley. We're going to watch Deedle. We're going to watch Deedle's victim impact statement. But there was, some controversy about it because of some things that were said and reactions to it and so forth. And I understand. I understand the response to that. And I think part of the challenge is that from a legal standpoint, we don't really know why we do victim impact statements. So I'm going to share with you this U.S. Supreme Court decision here, Payne versus Tennessee. This is a Rehnquist decision from 1991. And this is the case where the U.S. Supreme Court said basically it's okay to present this type of evidence in a sentencing phase of a capital case. There had been cases just a couple of years before where they said, no, you don't get to do this. It is just emotional. It is problematic for a lot of different reasons. It sets up a dynamic where you create a hierarchy of victims, right? Victims who have people who come forward and make an impact statement are now more influential than people who don't have somebody that's willing to come forward, or heaven forbid, a case where somebody isn't comfortable coming forward and talking about the impact to them. Like, for example, a sex case. Not every victim is going to want to come forward and talk about the impact on them. So, this had gone up to the U.S. Supreme Court. They'd said, no, you don't get to do this. Sentencing is supposed to be focused on the defendant, on the qualities of the defendant. And is the defendant amenable to treatment? Is the defendant, irredeemable and, dangerous? Always going to be an issue. But then we get this decision here in Payne. So here's kind of what it was about. So Booth is the prior case where they're talking about the death penalty was imposed, and so they had a sentencing stage of the process. The family members were allowed to speak. They were allowed to talk about, the crimes were terrible. The defendant is terrible. We've suffered as a result of this. And the U.S. Supreme Court said, Eighth Amendment prohibits that because it unless it relates directly to the circumstances of the crime, it's not serving the interests of that sentencing proceeding. So in a capital case, the defendant has to be treated as a uniquely individual human being. That's really what it's about. And so sentencing is supposed to be based on the character of the individual and the circumstances of the crime. This, by the way, is the justification for why juvenile sentencing has changed dramatically in the last 10, 15, 20 years, because the character of the individual, the courts have looked at that and said, you know, when you're talking about somebody 14, 15, 16 years old, their character is unformed. And so to conclude that somebody is permanently irredeemable, they are a throwaway person, we are going to put them to death, we are going to throw them away for mandatory life in prison without parole, based on a quality that is not fixed, that it could still change, that is really contrary to the purpose of what sentencing is about, especially in capital cases. So only the defendant's character and immediate characteristics of the crime may be constitutionally considered. And so to the extent that victim impact evidence presents factors about which the defendant was unaware and that were irrelevant to the decision to kill, has nothing to do with the blameworthiness of a particular defendant. It also could well distract the sentencing jury from its constitutionally required task of determining whether the death penalty is appropriate in light of the background and record of the accused and the particular circumstances of the crime. It's emotional and inflammatory. It's just by its nature. It's always going to be. You know, it's not. I'm not saying that because like somebody's doing something wrong. No, you're talking about grieving families and survivors who have been horribly victimized by somebody. Yeah, what they have to say about how that has affected them, that's going to be extremely, extremely emotional. Court's not supposed to be about emotions. It's just not. So if it's not about the circumstances of the crime, in this previous case, Supreme Court says you don't get to bring it in because it creates an impermissible risk that the capital sentencing decision will be made in an arbitrary manner. You don't have somebody show up to support, make a victim impact statement. Well, maybe that person won't get death. Somebody shows up and makes a victim impact statement, that person gets death. That's not the quality of the victim, the character of the victim, whether the victim has people that will come and speak for them, is not supposed to be what drives sentencing decisions. Okay, the victim is a victim. Victims don't have to be perfect. Victims often aren't perfect. It's just an unfortunate reality of the criminal justice system that victimization and perpetration are often really closely connected. They're in the same communities, they're in the same families, they're often the same people. You're a victim today, you're a perpetrator tomorrow. But it doesn't mean that the person who victimized you is somehow less deserving of a crime, of a severe punishment. Because what? Because you're not as good a person? That's just an awful, awful basis. Awful basis for criminal justice decisions to be made. So this case is departing from that rule. They're saying, look, two premises here: harm to the victim, harm to the family. It doesn't reflect on the defendant's blameworthiness, and only blameworthiness is relevant to the capital sentencing decision. But the assessment of the harm that's caused by the defendant is an important concern of criminal law. And so that is what the victim impact statement is intended to be directed towards. So let me find where we're at here. So it's focused on the consideration of the harm to the family, and that's essentially an appropriate thing for the court to be able to consider. And that's why victim impact statements in general are to be allowed. It's for information purposes, for the judge to know and for the public to know. This is what crime does. Okay, that's why I used the thumbnail that I did today. This is what crime does. Okay, this is victimization. This is what it looks like. It's serious. It's ugly. It's bad. This is why we have to have a criminal justice system, as flawed and awful as it sometimes is. When we look at high profile cases, there's a selection bias that goes on. We're more likely to be looking at cases where there's a problem, cases where maybe you do have somebody that's wrongfully accused. Maybe you do have a situation where there's been police misconduct, something like that. There's been reason to litigate and to pursue the case. But that's, again, just that's often not it. Okay, the bulk of the criminal justice cases going through are people that have been victimized. We can't forget that. That's why we have it, is to vindicate their rights, say, no, that was wrong what happened to you. We aren't going to stand for it. There are going to be consequences for it. We as a society have boundaries. So understanding that harm, that's really the justification that the law recognizes. He also points out in this particular decision that, look, if you're in a capital case, the defense gets to present mitigating evidence. It wouldn't really be fair for the state not to be able to answer that with their own. I'm not really seeing that necessarily as equivalent, but that's the ultimate justification. In recent years, there has been, not in the case law, but just kind of in the commentary, the law review articles and academia and things like that, that it's also about rehabilitate. It's about not rehabilitation. It's like therapeutic. It's therapeutic for the victims to have this opportunity in the process to be able to confront the person that victimized them if they chose to do that, and have the opportunity to say, what they need to say for there to be healing. There's some problems with this. Again, this is not a justification that's ever been legally recognized in court, but it also really hasn't been studied at all. There's never been a study about do people who give victim impact statements, are they better off than people who don't? Is it in fact healing? We don't actually know that. We just kind of think it is. One of the concerns I have with it is it's extremely insidious, because it puts the victim impact statement now in a posture where if you are critical of it, you can't do that, because now you're anti-victim. You're hurting victims. You're taking away their therapeutic benefit that we've just kind of assumed is there, but never actually established is a thing. So it's all quite complicated, guys. It's quite complicated with the victim impact statements. Many states, including Idaho, have statutorily or in constitutional form adopted victims' rights provisions. So Idaho's statute gives victims the right to speak at certain proceedings, including sentencing, the right to notice, the right to kind of be kept in the loop by the prosecuting attorney about certain decisions and things like that, the right to information about victim services, crime victim compensation, and things like that. But the victim impact statement, it remains a little bit murky. So I wanted to give you that context for those of you who watched, maybe weren't sure what or why we are watching what we're watching, concerns about propriety and so forth. There was, I don't have it on hand. It's interesting. Let me see if I can find it real quick. Here it is. I was able to find it. Okay. Let me just share this with you real quick. So this is a statute that's specifically about sentencing in capital cases. Now, I think, again, we were in a very weird posture in this case where it's no longer like a capital case because there's no finding of aggravating circumstances. That's not, we just watched the whole plea. We looked at all the documents. Not a single thing in it was there ever a finding of an aggravating circumstance to support capital sentencing. The ones that they had alleged were that it was extreme cruelty, which doesn't seem like that hard of a conclusion to reach once you reach a determination of guilt. And then also committed in the course of a burglary is a statutory aggravating circumstance. That would also follow from the nature of the plea here. Just a point of clarification before I move on, because I know there's often confusion about burglary. Like, what's the burglary? He didn't steal anything. Burglary isn't about theft. It's common, but that's not legally what the charge is about. The charge of burglary, conventionally at common law and in the state of Idaho, is based on entering somebody's property with the intent to commit a crime inside. It doesn't have to be a theft crime. It can be any crime. So, entering somebody's house without permission, intending to murder them, that is a burglary. So there would be grounds for aggravating circumstances to be found here, but they weren't stipulated to, they weren't found. But we're still getting the capital sentence here, right? Because not the life with the possibility of parole in 10 years that is mandatory for other homicide charges like we looked at earlier. So I'm pointing that out because the statute is dealing specifically with sentencing in capital cases, and it's a little bit ambiguous at this point about whether that is what we in fact are proceeding to. But what I want to point out here is in section 5 of the statute, where it does talk about the victim impact portion of the sentencing proceeding. And so that's basically all of this right here. Information concerning the victim and the impact that the death or aggravated lewd conduct of the victim has had on the victim's family is relevant and admissible. Such information shall be designed to demonstrate the victim's uniqueness as an individual human being and the resultant loss to the community or impact caused by the victim's death. I'm not going to say that. Characterizations and opinions about the crime, the defendant, and the appropriate sentence shall not be permitted as part of any victim impact information. So the statute kind of clarifies, again, what this process is supposed to be about, what it is supposed to be limited to. It's not supposed to be an opportunity to go out and name call and taunt or things like that. Do what you will with that information. So with that, I would like to turn us to the victim impact statement that I thought it embodies the reason why we do this. Okay, this is what they're for. This is like the best example of what I considered to be a very powerful, meaningful victim impact statement. So this is Kim Cheeley. This is the grandmother of Madison Mogen. And I'm going to go ahead and just cue it.
My name is Kim Cheeley. I was Maddie Mogen's paternal grandmother, as Ben Mogen, her father, is my son. I'm here today with my sister Lori Cheeley, Maddie's great aunt, and my son Ben Mogen, and my daughter-in-law Corey Hatrock. I'd like to begin by thanking a number of people involved in bringing this case to closure. In my daughter's words, the plea deal the prosecution team reached this month is one that punishes the perpetrator of this horrendous crime, protects the public from further harm, and allows all of us who knew and loved these kids the time to grieve without the anxiety of the long and gruesome trial, the years of appeals, and potential for mistrials along the way. My family and I are so grateful to Bill Thompson and his prosecution team for their dedication and painstaking work that forced the perpetrator to admit his guilt. We want to thank the Idaho State Police, the Moscow Police Department, the FBI, Judge Hippler. We'd also like to thank the University of Idaho officials who have treated the families of the victims with such dignity and kindness, and who have honored the 4 victims beautifully. Maddie was my first grandchild, so when she was born, all her grandparents had the distinct pleasure of deciding what we'd like to be called. I chose Nana, pretty original. But when Maddie was about 1.5 years old, her papa, Ben's dad, and I were planning to visit the new little family in Oregon. Maddie didn't have an extensive vocabulary at the time, but for some unknown reason, she called bananas ba-deedle-deedles. When Karen and Ben told her Nana was coming to visit, she figured, I say deedle-deedle for that word. So I became deedle-deedle, shortened to Deedle when she was about 6 or 7, and I was Deedle all her life. I don't think her stepdad, Scotty, ever knew my given name was Kim. Maddie's and my birthdays were 1 day apart, and a couple years before she was killed, she gave me this necklace with Deedle and Maddie engraved on it. And I added an angel wing, and it's one of my treasured possessions. I also got an angel wing tattoo. Never thought I'd see the day, but along with many members of our family, replicating the one that Maddie and her sorority sisters had. I wanted mine where I could see and touch it often. From preschool through grade school, I stopped teaching piano lessons early on Wednesdays and picked Maddie up for bubble baths, brownies, and books. It was our special time together. And she went home those nights in her jammies with a pan of warm brownies for her family. Although Karen and Scotty raised Maddie and did such a lovely job of parenting, we Mogans were lucky to have her for holidays and many other family gatherings. We'll always have our treasured memories of Maddie growing up in our big, extended, cooperative family. And I thank Karen and Scotty Laramie for being so generous and open and sharing Maddie with her Mogan side of the family. When the 4 kids were murdered, the foundation fell out of our world. Initially, the fear was truly debilitating. The first 6 weeks were excruciating. Despite the vigils, memorials, candlelight gatherings of students, friends, family, community members. After the arrest, in the past 2.5 years, my family has lived with grief, with the effects of traumatic grief, of which I was blissfully unaware before all of this. I now have a stack of books on grief. I've attended grief classes at hospice. I've tried EMDR, a technique that helps replace disturbing visions with something more comforting. My son, Ben, his 2 sisters, Maddie's aunts, and I have all experienced depression and anxiety and sleep disturbance, requiring medical intervention at times. We've all sought counseling off and on. The struggle with media attention was extremely difficult, especially for Ben. No one should live through the violent murder of one's child. Some days it's beyond me how the parents of these kids are still upright. I'm thankful for the strong families and communities that are supporting the survivors. At the time, I could think of only 2 blessings surrounding the horrific murders. One was that Ben was living with my partner Tom and me at the time, and that we could support each other emotionally through it all. Sadly, Tom died a year ago of a rare brain cancer, and he won't be here to see justice served. He was our family's rock, and we all miss him every day. A second blessing is that my mother died of COVID several months before the kids were killed, and she didn't have to live through the horror. It was difficult to identify blessings. So we've all lost our dear child and a future with her. I ache for the loss of the dreams that she and her true love, Jake, held. And my heart goes out to Karen and Scotty and your side of Maddie's family. You've had more than your share of loss. My heart aches for the kids' roommates and the families of the other victims, and also the family of the perpetrator. Going forward, we Mogans are choosing to put our energy and focus into honoring Maddie's too short life and sweet spirit by celebrating Maddie May Day, which my two daughters established. On May 25th each year, Maddie's birthday, we encourage folks to do random acts of kindness in Maddie's name. In my daughter Katie's words, may we all protect our peace in whatever way possible, unite in community, and focus on joy. Please do an act in kindness in Maddie's honor during this week, so a glimmer of Maddie's light may live on. Thank you.
Thank you, and appreciate your courage, and bless you and your family.
Thank you.
So, I mean, it's such a powerful statement for so many reasons. Very focused on that core purpose of why we do the victim impact statements. It's about Maddie. It was a beautiful recollection of some fond memories of her, and that's what's going to emphasize the loss. That's what just allows you to appreciate the gravity of what they'll never get to have again. I loved, I just, I could praise Kim Chi-Lee for a long time. There's so much of what she said that I appreciate so much. I love her attitude of looking for blessings, even in the darkest, most horrible circumstance that I think anybody could imagine going through. Still looking for blessings. And, it's hard to find them. It's hard to find them when you have to consider it a blessing that somebody has passed on and didn't have to go through this. Yeah, that's bad, but it is a blessing. And the last thing I appreciated so much was her recognition that Bryan Kohberger's family is suffering too. And they are suffering silently. They are suffering without sympathy. They didn't ask for any of this. There's no indication that they had any reason to believe that he was capable of something like this, that he was going to do something like this. It's not just the families of the victims that get destroyed by this type of crime. I know we heard stories about how Bryan Kohberger's sister, I think, lost her job when he was initially arrested. Put yourself in their shoes. Just imagine what that's like. They There was that series. God, was it on Netflix? I can't remember now. Adolescence. It was out like within the last year or so. Produced in the UK. It's very well done, I thought. But that was kind of one of the focuses. I don't want to spoil it if anybody hasn't seen it. But the impact that crime like this has on a family and having to come to terms. You know, when I don't have kids, you know, but I am one. Have parents, friends that have kids, et cetera, et cetera. And you know, when a mother gives birth to a baby and holds that baby and looks at that baby for the first time, and just all you see is the dreams and hopes that you have for that child, the future that they could have, the greatness they could accomplish in the world. And a parent's always going to see their child like that. They're always going to see their child as the potential of that dream they have about what the child can be. And so to have that dream just shattered, destroyed, devastating, absolutely devastating. And they don't get sympathy. So I just appreciated that so much from Kim Cheeley, that in the middle of her own suffering, her family has suffered so much that they have to look at the death of one of their family members as a blessing, but she still has it in her heart to think of others and to think of the people that aren't so easily recognized. Just an enormously compassionate woman. It was very impactful to me. Just goes to show, you know, compassion is not a zero-sum resource. You don't take anything away from anybody else by having compassion for more people. It's okay. You can empathize with the pain of Bryan Kohberger's family, and it takes nothing away from your empathy for the pain of the families of the victims. So I found that to be by far the most powerful of the victim impact statements. I am going to move now to the state's arguments to the court so that we can discuss what Mr. Thompson had to say about this process.
State can argue.
Thank you, Your Honor. Just as a housekeeping matter to start, there will be the issue of restitution. That is, the documentation is being gathered, and we ask the court would defer that for 30 days so we can present it in an orderly fashion and make sure it's comprehensive for everyone.
Any objection to leaving restitution open 60 days? All right.
Thank you, Your Honor. I think it's necessary and appropriate to share for everyone here, including the court, the background that brings us in front of Your Honor today for these proceedings. As the record reflects, and as everybody in this courtroom knows, the defendant has pleaded guilty to all 5 counts charged in the indictment. Under oath before Your Honor, he has admitted that the charges against him are true. He has reassured the court that he has not been coerced or threatened to make those admissions. And Your Honor did an extraordinary job in taking the pleas back on July 2nd. We appreciate the court's discipline and insight. The defendant has also waived appeal on the multitude of rulings from this court and Your Honor's predecessor in Latah County on dozens, literally dozens of motions seeking to dismiss the case, seeking to control or limit evidence, seeking to offer evidence that would not be appropriate. And we appreciate the court's consistent rulings based on the law, based on the facts. As Your Honor will recall, on June 18th, it's just really not that long ago, we appeared before this court for arguments on what became the defendant's final motions to this court. Motion where they wanted to offer evidence suggesting that other people were responsible for the defendant's actions, and the motion seeking essentially an indefinite continuance of the trial. It was readily apparent to all of us in the courtroom from Your Honor's comments that those motions were not going to be granted. So we returned to Moscow and continued with what we had been working on for months in preparation for trial. We had no qualms about going to trial if trial was what was necessary and appropriate. The following week after we were in court, we were approached by the defense with an inquiry about a possible plea. And I can tell the court this is the first suggestion ever that there was any consideration, because indeed the defense had maintained from the beginning that Mr. Kohberger, the defendant, was factually innocent. It's clear that the reality of the evidence and the case that had been investigated and prepared and that we were ready to present in court became a reality. Our reaction, among other things, was to reach out to all the families. And in fact, later that week, on Thursday and Friday of that last week of June, we met with representatives by teams, virtual meetings with representatives of all of the families. And we talked about the status of the case and the upcoming trial and things that related to the trial. And we also let them know that there had been an inquiry about whether there might be an offer for a plea. And we asked the family members for their thoughts and feelings. And they were candid. And they have been candid since, and we respect that. And we understand, recognize, and acknowledge that there was a difference of opinion among representatives of the different families. We understand that. One of the challenges of this case, one of the unique things about this case is we have multiple victims, each unique unto themselves, their families and friends unique unto themselves, and all of them entitled to their opinions, all of them entitled to their thoughts. Over the following weekend, our prosecution team, very skilled attorneys who were personally as well as professionally deeply invested in this case, met. And we talked, and the decision was reached. Well, to start with, were there to be any sort of plea offer or discussion, there's only one possibility. And that would be for the defendant to plead guilty straight up to all charges. There would be no bargaining about counts. There would be no bargaining about reduced sentences. And so we made the proposal to the defense that if the defendant was willing to plead guilty up front to all 5 counts as charged and waive appeal of the court's myriad decisions during the past 2.5+ years on all these motions that would have consumed years, if not decades, of time in the future. By the end of the weekend, we were notified the defendant was prepared to plead guilty as charged and factually acknowledge his responsibility in court for these horrible crimes. Obviously, those discussions and negotiations were confidential. And as Your Honor noted, I believe that was necessarily so, because if the defendant had decided not to plead guilty, it would have been devastating to our jury pool for there to be public information that there had been even consideration by either party to a plea resolution. And protecting the prospective integrity of a trial after so many years was paramount. So the end of the weekend came. We notified the victims' families of what had occurred. I recognize and acknowledge personally, and I respect the fact that of these fine, suffering people here, not everybody agreed with the decision we make. I accept that. It's my responsibility in the end. I recognize that that's the duty of the office that I hold. So now, it is time for the judicial system to impose final judgment and close the door on this chapter of these tragedies. As the court is aware, by the agreement of the parties, it is the state's prayer. Perhaps have the Elmo police turned on. Thank you. That on count one, the felony burglary, that the court sentenced the defendant to the maximum period of 10 years fixed in the custody of the Idaho Department of Correction. Then on count two, that the court sentenced the defendant to fixed life for the murder of Madison Mogen. On count three, that the court sentenced the defendant to fixed life for the murder of Kaylee Goncalves. On count four, that the court sentenced the defendant to fixed life for the murder of Xana Kernodle. On count five, that the court sentenced the defendant to fixed life for the murder of Ethan Chapin. And the state further prays that these sentences be ordered to run consecutively, back to back, not at the same time, to recognize and respect the unique individuality of each of these beautiful young people whose lives were taken brutally and for no reason. And hopefully now, as we have heard earlier this morning, it is time to afford the families and the friends and the community and the state of Idaho and the nation and the world to move forward. We can't undo, and we can never undo, the horror of what occurred on the early morning hours of November 13th, 2022 at 1122 King Street in Moscow, Idaho. For a long time, the presiding district judge in Latah County was John Stegner, who eventually became a member and a justice of the Idaho Supreme Court. And Justice Stegner often observed that even God cannot change the past. But everyone in this room has the ability to take themselves forward. And we want the judicial system to afford them the opportunity today to do that. From today forward, our memories should be focused on these innocent victims whose lives were taken, on their families, on their friends, on the community. The court has heard discussion, talk today, reminiscences today about a special family that our victims shared, not just their natural, legal, and biological families, not just their university family within their sororities, for example. But this family. This is the picture taken on November 12th, 2022, of the special family of 1122 King Road. And you can see all 6 of these dynamic, vibrant, loving, special, innocent faces taken together just across the street from their residence, and barely 12 hours before 4 of them would be brutally murdered in their sleep. They've been described consistently as being bright, caring, vivacious, with futures we can only imagine now. But they were, and they remain, a special family that I think we should all recognize and appreciate. So it's time to move forward. There have been a number of statements directed specifically at the defendant today. I have one last thought. After Your Honor imposes judgment and sentences the defendant to spend the rest of his life in prison, in other words, sentence the defendant to die in prison, he's going to stand up in the belly chains and leg irons that he's wearing today, and he's going to be escorted into the custody of the Idaho Department of Corrections. And the door will close behind him forever. That is the closure that we seek, that all of these people, these loving friends and family deserve, so that we can move forward. Thank you, Your Honor.
So I want to pause here because, we got, a little bit more of the sort of story of how the plea agreement came together, and it was defense initiated, and it was in contemplation of rulings that would limit the ability to present a defense. Of course, Mr. Thompson has to present this as if it's like something, not their duty to raise reasonable doubt as defense lawyers, to raise all alternative perpetrator theories, evidence. Of course, all of that is under seal. We don't know what it was. But even with just what is public, it's hard for me to conceive how you could effectively go forward and not raise some of these issues. The primary one being untested male blood on the handrail. I don't know how you how you could be effective as a defense attorney and not point out that piece of evidence. No, we don't know where it came from. We don't know who it belonged to. Sure, it could have been there, for a while, I guess. I don't know. I don't know how clean this house was. I don't know the circumstances of any of it. But blood tells a lot more of a story than a few skin cells. Of course, you absolutely have to raise that. And he knows that. So to present that as if, I don't know, that's some bad thing that the defense lawyers did, and just continuing to kind of shit on them for doing what their role in this process is to point out, if we go to trial, yeah, there's a lot of unanswered questions. Of course you would have to raise blood. Of course. It's just insane to me to think that like somehow that would be a bad thing. You're preparing to go to trial. You don't have a plea deal. But what, you're not gonna try to raise that? Of course you're gonna try to raise that. Oh, and the explanation for why they didn't search it, by the way, yeah, that's bullshit. Complete and total bullshit. The explanation was that they can only put like one suspect's DNA into CODIS, or it will like erase the other ones. Absolute, complete, total bullshit. It's not true at all. There was just fairly recently, it was in the Long Island serial killer case. I remember this came up because there, number of unsolved crimes. Not all of them have been tied to him. Some of them have. But as part of the investigation, once he was identified, they started a process of going back through and reviewing whether there was, other DNA that they could run through from these crime scenes and see if any of it might trace back to Rex Heuermann. Like literally the standard for being able to put, like, it's not unlimited. It's not a free for all. You get to put anything you want into CODIS. No, but the only limitation is that it has to be like investigative. There has to be some reason to think this could be the perpetrator. It's not a known person. It's not a known sample that you've obtained. It's not obtained under circumstances that don't have anything to do with the crime, right? Like, don't use CODIS for personal purposes kinds of reasons. But unidentified blood DNA at a crime scene, yeah, no restriction whatsoever on running that in CODIS, seeing if it comes back to somebody. Yeah, absolutely. The defense lawyer is going to raise that type of thing. And that is alternative perpetrator evidence. Now, again, we don't know what's in the motion. It's sealed. And I don't know what we're ever going to be able to see about that. He's going to talk about that at the conclusion here. But didn't appreciate that that little dig. It's just it's uncalled for. It's unnecessary, and everybody involved in the process in court knows that. So it's not a statement that was made for court. Okay, this was just made to shit on the defense lawyers publicly. Didn't appreciate it.
Thank you. All right, does the defense have evidence to present today?
No.
All right. Does defense wish to make argument today?
Runner, we do not wish to make arguments. Mr. Kohberger, along with his legal team, is prepared to report to enter judgment.
All right, Mr. Kohberger, you have an opportunity to make a statement if you wish to. I take it you are declining.
I respectfully decline.
Well,
So nothing at all from the defense. This isn't, under the circumstances, shocking to me. Of course, there was always the possibility that he would voluntarily allocute. I never expected that. I did think it was possible that maybe somebody from his family would speak on his behalf, but there's nothing really to achieve from it in a case like this. You know, the conclusion is kind of foregone. I kind of suspect that if this was a case where there were no cameras, maybe we would have. But I can just only imagine that the hate, you know, that the family members would have gotten if they had dared to get up and say, here are some redeeming things that we saw about Bryan Kohberger. This is just an unfortunate aspect of the criminal justice system, I think, where talk about it in terms of the black hat and the white hat. You know, things get treated very black and white. And somebody is either, you know, a total monster or a perfect angel, and there's no in between. And unfortunately, the reality is far more complex. I've said a few times that, you know, I've represented people accused of some really horrifying things, really bad things. I've represented thousands of people, and I can count on one hand the monsters in human skin that I ran into, like the ones that are, yeah, just not human. Most people, it's far more complex like that. It's just there's a reason why people are the way that they are. No, it doesn't excuse anything. This is not making excuses. This is not justifying. Of course not. That's ridiculous. Nobody justifies the murder of 4 people in their beds. But understanding is not inconsistent with justice, and often, you know, can be helpful. So very common in cases, even with guilty pleas and things like that. Yeah, you get families to talk about them, talk about the good things about them that you know, nobody else is going to see. Talk about potentially, you know, where and how things have gone wrong. Unfortunately, one of the best predictors of criminality is having a parent who's a criminal. And a lot of these issues are generational. One of the hardest parts of my job when I was working in a small community, so you handle lots of different types of cases. And one of the hardest things that I would have to deal with was representing a kid in foster care. And then a few years later, you know, kid is aged out and I'm representing that kid in adult felony court now. And I know that kid's not a monster. I know that kid never had a chance. Now, obviously, that's not Bryan's story. But, you know, we don't know now. We don't know what his story is. We may never know what his story is. And, you know, maybe that's fine. Maybe we're not supposed to care. You know, Bill Thompson's attitude is now just look away. Not about him. And I certainly understand that. Very much understand that. But I think it's important. I think it's important to understand knowledge is power. Knowledge is strength. The more you know, I think the better equipped you are to just be more prepared in the future. There is a fair amount of scholarship right now that's kind of going on. It's quite controversial, as I'm sure you can imagine when I say what it is, about the potential, I don't want to say link, I don't know. There is a higher rate of violent crime associated with an autism diagnosis than with no autism diagnosis. And so there's a lot of study in going on right now into why that is. Some of it may have to do, there's a lot of variables, a lot of noise. Some of it can have to do with how, likely you are to come into contact with the criminal justice system because you are, weird, things like that. So there's a lot of open questions, and it's something that would be very helpful to understand because we don't want more violent crime. Anything that we could know that could help us potentially intervene, come up with better interventions, come up with better treatments, prevent it from happening in the first place. Is that not a good thing? My hope always in a case like this is that there's some way to get something positive out of it. Okay. You're never going to be able to make up for a crime like this. Of course not. Of course not. But you can still make a positive contribution. I see that, see that with some regularity, folks with long prison sentences. And they find a way to make it positive. They find a way to help others. They find a way to just make positive contributions instead of negative ones. And surely that's something we want to encourage. That's not a bad thing. Nobody's ever going to say, oh, yeah, that makes up for those 4 murders that you committed. Of course not. But so if you can advance understanding, knowledge, turn it into something positive. Isn't that the best that we can hope for out of pretty much all tragic circumstances in life? Try to get what positive you can out of it.
Please. All right, let me start this morning by acknowledging and thanking those that have come here today in support of their loved ones. And I appreciate your courage and your strength. And I hope that you are able to move on as best as possible. Thank counsel for the professionalism that they've exhibited throughout this case. It has been my great honor to preside in this case and to help bring, to the extent possible, some resolution and hopefully justice to this case. During the quiet morning hours of November 13, 2022, a faceless coward breached the tranquility of 6 beautiful young people and senselessly slaughtered them, 4 of them. Who committed this unspeakable evil was unknown for several weeks, but due to the killer's incompetence and outstanding police work by numerous local, state, and federal law enforcement agencies, the person that slithered through that sliding glass door at 1122 King Road now stands before the world and this court unmasked. This unfathomable and senseless act of evil has caused immeasurable pain and loss. No parent should ever have to bury their child. This is the greatest tragedy that can be inflicted upon a person. Parents who took their children to college in a truck filled with moving boxes had to bring them home in hearses lined with coffins. The loss this killer inflicted was not just the death of these people's children, siblings, grandchildren, as we've heard today. It has ripped a hole in their soul, destroying a special part of their very essence. Any person who is a parent defines themselves foremost as such. It is their existence and purpose of being. And it has been stolen from these parents. None of us have experienced the loss these victims have in the unspeakable way that they have. And therefore, none of us can, nor should we, question the way in which they have handled their loss. Whether that be in private mourning, removed as far as possible from this media circus, or in front of a camera demanding retribution with the loudest megaphone. I've listened intently to the stories and pain that have been shared today, with great awe at the courage and resilience of the surviving family members of those wonderful children. I've listened also to the surviving roommates, both in person and through their friends. And I can't think of how, frankly, courageous they have been despite the hell that they have faced by uncaring people who have come up with all kinds of crazy theories about two kids simply being kids.
Well, I'm going to pause it here because, of course, the judge's remarks are quite strong. And, you know, Judge Hippler is in many ways kind of, I consider him almost like iconic for a certain type of rural Western judge. Like, not uncommon. Not uncommon at all in his attitudes. Probably a little smarter than most. He's very, very smart, very intelligent judge. Writes excellent rulings. But, you know, quite no nonsense and quite well, he's good at judging, isn't he? He's good at judging. I didn't appreciate the inference that if you have theories in the case, it's because you are uncaring. I think it is the most caring thing in the world to want answers and to have questions. And if there are narratives that don't seem to be maybe supported by the evidence, that you would question those, even if they're coming from law enforcement, from police. He's very clearly got a strong law enforcement bias, has from day one. And way back, guys, remember way back when we were doing the motion for the change of venue? I was like, I'm telling you, if I'm a defense lawyer, I'm really questioning if I'm bringing this motion because of the risk of losing Judge. Judge would have given a very, very different statement at this sentencing. Now, I definitely appreciate that lines have been crossed when it comes to theories and efforts to investigate and things like that. There is a distinction between having a question and making an accusation. I think it's normal to have questions, and the case raises a lot of questions. And I think some people are satisfied with the answers that they've gotten from this process. But I think a lot of people are not. I'm not prepared to say they're wrong based on what's been presented, based on the evidence that's been presented. So I think the judge has looked at this from a standpoint of seeing the potential harm, which I do. I understand. I understand very much. Somebody who has been victimized by a crime like this. And just what you would be going through with your own trauma and your own efforts to cope, find a way to move on with your life, but then to be re-traumatized, being accused of horrible things and stuff like that. I understand. I really do. But I just don't like the broad brush that he's used here. Because it has an aura of how dare you question the official narrative. Well, this is America. We're not only allowed to do that, that's kind of what we're about. we sort of stand for that. We don't just bow down to the government because the government says this is what happened. Okay, we're founded on recognizing that the government power can be intoxicating and corrupting. And it always has to be monitored and kept in check. So asking questions about what the government's done and the information that they've developed and the conclusions that they've drawn from it is one of the most American things that you can do. And if you care about justice and getting it right, I will say it again, say this many, many times. Skepticism is scientific. If you are not asking questions, you're not engaging in a truth-finding process. But, Judge Hippler is not one for nuance. Thought that was unfortunate. There's going to be a little bit more, inability to see nuance as well. But we'll let him continue.
The parents, siblings, and other family members who have spoken today are designated as victims in our legal system. But going forward, I hope that they can shed that label, as it gives too much power to the evil that condemned them to that role. They are and should be known as survivors, fighters, and foremost as witnesses to the tremendous lives of value and unbounded promise of these 4 young people. But those speaking today and those who did not speak, but who carry this same burden, this same loss, now carry forward the memories of these now perpetually young people, these forever children. These survivors carry the responsibility of ensuring that the voices of these children, Maddie, Kaylee, Xana, and Ethan, are never forgotten, and the positive impacts that they have had on so many lives are never minimized, and that the love they shared, the light that they shined onto others is forever celebrated. As we sit here today, this case is ending, and we are now certain who committed these unspeakable acts of evil, but we don't know, and what we may never know is why. I share the desire expressed by others to understand the why, but upon reflection, it seems to me, and this is just my own opinion, that by continuing to focus on why, we continue to give Mr. Kohberger relevance. We give him agency and we give him power. The need to know what is inherently not understandable makes us dependent upon the defendant to provide us with a reason, and that gives him the spotlight, the attention, and the power he appears to crave.
So let's pause this again. Okay. Of course, certain things are unknowable, but other things are very knowable. For example, how? How did he do this? One person in the time frame that's been provided, without apparently knowing who any of these people are, being in the house before. You know, typically you would like know the layout of the house. You would know the habits of the people. It's part of like the prep that you would do if you're premeditating a crime. And it doesn't appear that he did that. The absolute savagery that was perpetrated. But not a scream. A few like muffled thumps. Some descriptions from Dylan, you know, like noise, but nothing raising the alarm. He's not injured in the course of any of this. And again, you know, the lack of any kind of transfer DNA, there's no footprint, there's no trail, like nothing. How? That's knowable. Okay, that's very knowable. And I think it's unfair to suggest like, oh, that's just morbid, you know, morbid curiosity or something like that. No, people want to know, are we sure it's just him? Look, he said, I did it. Okay. He said, I'm pleading guilty because I am guilty. I'm pleading guilty because these allegations are factually true. He said it, you know, 4 or 5 different ways. He said he did it. I got to take him at face value at this point. Okay. I'm not going to argue with him. Did you do it by yourself? No answer. That's knowable. Okay. I stopped it here too because, you know, the attention and notoriety that he appears to want, I got to tell you, I don't know where he's getting that at all. I don't know where he's getting that at all. He hasn't said a word. He's said like barely 5 words in court. The minimum responses to, you know, the questions that he gets. He hasn't been, you know, a behavioral problem in any way. You want to see somebody who wants attention, go watch Daryl Brooks. Go watch that trial again. That's what that looks like. You see that a lot. That's not what we have here. Part of the problem with the information void and the lack of curiosity about getting answers to some of these questions is that it just creates this vacuum for people to project whatever they want. And I mean, that's fine. It's not illegal or anything like that. It's just, is that helpful? And is that justice? Because it comes off a lot more like scapegoating. Now, again, I'm not saying he didn't do it. He said he did. We're going to take that at face value. But the whole notion of the scapegoat, you know, is this idea that you have this guilt as a community that you need to project onto a victim. And so you do that. You go and you just, you know, expiate all of this, you know, anger and denial and rage and so forth on this person that deserves it. And now you don't have to feel it anymore. And so if you don't care about the answers to those questions, I mean, that's fine. You don't have to, but it's just very inconsistent to me to not care about the questions, but also have like real strong opinions about the answers to those questions. I would be shocked, for example, if Bryan Kohberger tried to like write a book or do an interview or anything like that. Oh yes, I know there's issues with like Idaho has a Slayer statute, basically a special statute that says if you try to make money off of your crime, you're not allowed to. It has to be paid to the AG. It goes to the victims, things like that. Now I have a million questions about how that gets enforced, but nevertheless, let's just say yes, I recognize that that's friction. But even absent any kind of benefit to him like that, I'd be shocked if that happened. And I mean, I'll tell you why. Like, if the whole theory here, the whole theory of motive, which we don't know, and apparently we'll never know because nobody's going to ask, is he wanted to like commit the perfect crime or something like that. He just wanted to murder. He's a monster. He wanted to murder. He wanted to get away with it. He thinks he's better than everybody else. I mean, I don't think I'm too far off base, like characterizing a very common type of theory that I've seen out there. I wouldn't think he'd want attention given how badly he failed. Right? Like, if your goal was to commit the perfect crime, you did not commit the perfect crime because you're here admitting you did it. No, you wouldn't give interviews and write books and something like that. You would fade away into obscurity. You would like try to be forgotten, wouldn't you? I don't know. So I just find that I find that comment by the judge, he appears to want attention. It's just a little bit strange because it seems so unfounded. It really seems so unfounded. Yeah, maybe I'm wrong. You know, time will tell.
Yet, even if I could force him to speak, which legally I cannot, how could anyone ever be assured that what he speaks is the truth? Do we really believe, after all of this, he's capable of speaking the truth or of giving up something of himself to help the very people whose lives he destroyed? Rather, I suspect the so-called reason would be dished out in enticing, self-serving, and aggrandizing, untruthful bits, leaving people wanting more information, more insight, and thus enhancing even further the power he seeks to hold. Even if we could get truthful insight into his why, I suspect it would not in any way quench one's thirst for actually understanding why in the first instance. Because there is no reason for these crimes that could approach anything resembling rationality. No conceivable reason could make any sense.
So again, if we're getting to like the psychology and the motive, it's not necessarily about making sense. Like, you don't necessarily expect what makes sense to somebody who would commit an act like this to make sense to people who, you know, would never even be able to imagine doing something like that. It's not about being rational. It's about understanding. It's about just having the information and do with it what you will. I just have a hard time seeing how knowledge is bad and how, okay, yeah, it's going to be self-serving. People are always self-serving, guys, like pretty much everything, most of the time. Okay, there's some room for altruism. Sometimes we're altruistic, we're not self-serving. But most of the time, yeah, we say things that we think put us in a good light. We put stuff on our social media that we think makes us, you know, look good. We don't put our, first thing in the morning selfie on our Instagram. Like, yes, of course you're self-serving. You're also a self-serving, judge. Like, that's just a thing. It's not like, it's just how humans are. We have egos. But again, I keep coming back to the people that to me seem like would get the most benefit out of this is the surviving roommates. Because they're the ones that have to live with those unanswerable questions and that guilt of why not me? Why them? Why not me? Now, maybe I'm not, I don't speak for them. I don't speak on behalf of them. Maybe they aren't interested. But maybe ask.
And in the end, the more we struggle to seek explanation for the unexplainable, the more we try to extract a reason, the more power and control we give to him. In my view, the time has now come to end Mr. Kohberger's 15 minutes of fame. It's time that he be consigned to the ignominy and isolation of perpetual incarceration. I know there has been concern about him collaborating on books or movies or other media projects, and I truly hope that someone does not stoop to affording him this spotlight that he desires in the name of clicks, royalties, or profits. While criminal behavioralists should study him away from the spotlight in an attempt to prevent other would-be killers from acting on their worst impulses, there should be no need for that to spill over into the public eye. The great Idaho jurist Edward Lodge was known for trying to find something positive about every person he ever sentenced. And with over a half a century as a trial judge, that was a lot of people. This was often challenging, and I recall in one case he said that the best he could come up with was the defendant had good penmanship. Truth be told, I'm unable to come up with anything redeeming about Mr. Kohberger because his grotesque acts of evil have buried and hidden anything that might have been good or intrinsically human about him.
So that right there is, to me, writ large, this is why the family didn't speak. That's why his family didn't speak. This, I'm somebody that sits next to people like Bryan Kohberger in court, defends their rights, etc. To me, this is a remarkably unsophisticated view of the world and of humanity. Very incurious. I don't know who Bryan Kohberger is. I really don't. But I just have a hard time believing that anything and everything Bryan Kohberger has ever done in his entire life is bad and evil. One of the things that was often really hard with, in particular for me, gang cases, was that so many of the kids that would do the worst things for the gang, they were the best kids. They were the best kids. They were the kids that had work ethics. They were the kids that had ideals. They were the kids that had principles. They were the kids that were loyal. They were the kids that believed in something bigger than themselves. It's just that the gang finds those traits and captures them and distorts them into something terrible. And that was the worst thing about those cases for me, because of the potential that those kids had. If they had a way to apply those traits in a pro-social kind of way, they could have been phenomenal people. And so if you look at one of those kids and you're just like, well, he shot up a rival's house, so that outweighs anything that he's ever done. Like, you don't get it. You don't get it. You're not seeing not only what's really happening here, but you're really not understanding the problem. You're not understanding how this type of thing can happen. How a kid like that, what kinds of circumstances lead a kid like that to get captured and distorted and twisted and turned into something awful like that? So I think it's very unfortunate. It's very unsophisticated. I just don't know how else to put it. Just no nuance there. Very, very black and white. Bryan Kohberger has a black hat, therefore he has always had a black hat, always will have a black hat. And I think that that's unfortunate, because I think if you don't understand what brought people to this point, I don't think you have a good sense of what justice is and whether you're doing it. And you can't always do it again. You can't make up for crimes like this. You can't atone for them. But sometimes crimes like this are a much, much bigger tragedy than they appear on the surface, because of what led up to them being perpetrated in the first place. And it's just a shame. A shame to overlook that.
His actions have made him the worst of the worst. Even in pleading guilty, he is giving nothing hinting of remorse or redemption, nothing suggesting even a recognition or understanding, let alone regret for the pain that he has caused. And therefore, I will not attempt to speak about him further, other than to simply sentence him so that he is forever removed from civilized society. And accordingly, based upon his conduct and based upon the record before this court, recognizing the standards that govern this court's sentencing decisions as set forth in State v. Toohill, I hereby sentence Mr. Kohberger as follows. On count 1, burglary, 10 years fixed, 0 years indeterminate. I also impose a fine of $50,000. Count 2, first-degree murder of Madison Mogen. I sentence the defendant to a fixed term of life imprisonment without the possibility of parole, a fine of $50,000, and a civil penalty of $5,000 payable to the family of the victim. On count 3, for first-degree murder of Kaylee Goncalves, I sentence the defendant to a fixed term of life imprisonment without the possibility of parole, a fine of $50,000, and a civil penalty of $5,000 payable to the victim of the family, or to the family of the victim, pardon me. On count 4, for the first-degree murder of Xana Kernodle, I sentence the defendant to a fixed term of life imprisonment without the possibility of parole, a fine of $50,000, and a civil penalty of $5,000 payable to the family of the victim. On count 5, for the first-degree murder of Ethan Chapin, I sentence the defendant to a fixed term of life imprisonment without the possibility of parole, a fine of $50,000, and a civil penalty of $5,000 payable to the family of the victim. The sentences on counts 1, 2, 3, 4, and 5 shall run consecutively to one another. Restitution will be left open for 60 days. Defendant will be required to submit a DNA sample and a right thumb print impression to the Department of Corrections and comply with the DNA Database Act. I remand the defendant to the custody of the Idaho State Board of Corrections for to be imprisoned in an appropriate facility in execution of the sentence, where he will remain until he dies. Though you have waived your right to appeal, you do have a right to file a notice of appeal. And any such appeal must be filed within 42 days the date of the written judgment, which will be entered shortly hereafter. Though the appeal, you should be aware, may be deemed a violation of the plea agreement, and so I certainly suggest you discuss that with counsel if that is your desire. I ask the media and public present to allow the families to be escorted out first before they leave. Again, thank you to everyone for your stories today. I am strengthened by them, and I am encouraged by your humanity and strength, and God bless you. We're adjourned.
So that was that. Again, conclusion kind of foregone from a legal standpoint. Not particularly interesting. Yeah, I mean, he's got a right to appeal. You can waive it, kinda. Don't expect him to exercise it. However, I talked about that at the beginning of the live here, kind of what some of the extremely narrow pathways are to be able to appeal after a guilty plea where you've waived your right to appeal. So nothing obviously present there. I'm not anticipating it, but it is possible. The reason why it's important, though, is because that's going to set the timeline for what the judge has said is going to be his process for unsealing a lot of the documents that have been filed under seal in this case. So that was very much an issue, right? Part of the the problem with the lack of transparency, the reason for all of the theories, the reason for the questions, and so on and so forth. So much information being kept from the public, and the justification for that was always, well, we have to preserve Bryan's right to a fair trial. We can't taint the jury pool, can't have too much information out there, particularly evidence that may not ultimately be admissible at trial. Well, that justification is done now, okay, because the case is over and we're not having a trial. So that's no longer a justification. The only justification for continuing to keep things sealed are independent justifications that are typically based on privacy, all different kinds. You don't put people's social security numbers and their phone numbers and things like that out there. There's going to be other things like, again, the third party culprit, the alternative perpetrator, as they call it in Idaho, that motion and the evidence supporting that motion and so forth. Really not expecting a whole lot of that to be public. If it is, it's going to be very heavily redacted. And that is because the reason why there's limitation on alternative perpetrator evidence in court anyway is because that can have real impact on innocent people being named as a potential suspect in a court process. So what Judge Hippler had said is that he's going to go through he's going to let the time period for appeal elapse and then start the process of releasing the documents that have been sealed. It's going to be a process that he works in concert with the parties on. They go through and kind of identify what still needs to be kept private and what doesn't. And so there should be kind of a rolling process, I would imagine, of information being made public. Now, I am a little, be critical, like, why not? I am a little critical of that just because, like, you should have anticipated that kind of all along, that the justification for having the stuff sealed was not going to be perpetual. It's always a temporary type of issue. But especially, he's taking this very hands-on approach with it that I just don't know why that's necessary. The parties are the ones who filed it under seal. They're the ones who know why they filed it under seal. It just seems to me that you would put the laboring oar on the parties to show like what should not be unsealed at this point in time and why. I don't know. I don't know why the judge would need to go through and kind of like take the lead on making those types of determinations. But hey, if it doesn't take almost a year and still not getting information like is happening in Delphi with the trial exhibits and stuff, that would be great. So it will be an improvement. 42 days, much better than almost a year with still nothing. So that that's the conclusion of our sentencing hearing here. I kind of changed my mind. I said I wasn't going to bring up the press conference, but I actually kind of think I do want to, because I think I skipped. It must have been during the plea hearing. I couldn't remember exactly when everything took place, but it must have been during the plea hearing when Mr. Thompson talked about why he didn't make it a condition of the plea agreement for Bryan Kohberger to have to provide information. And so he did talk about that as well at the press conference. I don't necessarily want to watch the whole thing because there's a lot of, just like, thank you everybody for being awesome. But they did have a whole question and answer session that I think was pretty interesting, and so probably worth watching. So I am, hey, it's my channel. I can change my mind. I'm going to change my mind, and we'll go ahead and watch some of that press conference. So let's go ahead and take a look.
Thompson from the prosecutor's office and the two lead investigators, Brett Payne and Darren Gilbertson. Just a couple of things before we begin. We recognize that everyone has a lot of questions. We're going to try to do our best to get to as many as we possibly can. Also, keep in mind that there are still some things that we are unable to talk about because of either privacy interests for the victims and their families, and or they are under seal currently in the court. So if those items do come up, then that will certainly be the answer that you will receive. And to keep this sort of orderly, I will try to be the one to point out who's got their hands up. Right there.
Chief Jonger,
yes.
Crime 2 in Spokane. What more can you tell us about the release documents that the police department is working on putting online, and what can you expect from that?
Certainly. As we put out in that press release, I hope everybody can understand the immense amount of information that's in this investigation is going to take a lot of time to prepare. It has to be gone through legally to be redacted or figured out whether or not it can actually be released. So I did get word today. It sounds like our website will be going live hopefully this afternoon. There should be another press release coming out in the next few hours to show that website so that people can start accessing that. Initially, what is going to be on there, and certainly this is just for the Moscow Police Department because we're only the holders of our records, but it will be all of our police reports from this investigation. So just the documents there. They'll be redacted, ready to go, again, free of charge for the public. We want to be as transparent as we possibly can, so we wanted to get those out to everyone.
Chief, from the very beginning, your department was saying this was a targeted attack. Can you now say who was the target and what's your evidence to show that?
I'll turn that question over to the investigators to answer that one.
Well, I think Darren and I have, the evidence suggests that there was a reason that this particular house was chosen. What that reason is, we don't know. We don't know who the target was, and we're not going to speculate on that up here today. But we can tell you that for whatever reason, Mr. Kohberger chose that residence. Perhaps it's the location, layout, we don't know. But that's, to the best of my knowledge, that's what that statement likely led to.
So this, I think, this is not a particularly good look because that's not targeting. Okay, that's not targeting. That is literally choosing at random. And you guys might remember in the days immediately after this crime, it was terrifying. Okay. People were terrified. They had no idea why it had happened. And so they had no idea if there was a continued threat. And so Moscow police put out this statement that, it was targeted attack, appeared to be targeted and nobody else, you didn't need to worry. There was no like ongoing community safety issue. And seems to me this answer is really saying it's bullshit. We came up with some semantics because the crime happened in a house. He chose the house. Of course he chose the house. If a crime took place in a house, But it's like literally the opposite of a targeted attack. You have no idea why he went into this house. That's random. That's a random selection. That's the opposite of targeted. So I think he's just kind of disclosed that that initial public statement that MPD made to try to calm the community is bullshit. They had no idea.
During Kaylee got their page too, there was a social media account that surfaced that has long had speculation that it was Bryan Kohberger. Can you talk at all about the Papa Roger potential connection, if any?
Right. There was no connection. There wasn't at all. And we looked into every bit of it. We took a deep dive into it. We researched it. We utilized. It was not. It was not.
So that I think is important. That was a big feature of the most recent documentary that came out, the A Night in Idaho. The fourth episode of that documentary really focused on the Papa Roger theory. And of course there are certain folks I don't acknowledge here because they don't deserve attention, that flout that theory a lot. So confirmation that's not true. It's not him. Who is it? I don't know. Seems possible to me, the theory that it was law enforcement. Law enforcement ran an account, kind of try to flush out more information or something like that. But we don't know. But bottom line, not Bryan Kohberger. Speculation and documentaries to the contrary.
Thank you. We can cut that off.
Is it possible that there was a second murder weapon used, not just the knife?
Is it possible? All the evidence shows and tells us that he used a knife, a K-bar knife, and that's a weapon we believe was used to commit all the murders. Here.
It sounded like the Gonzalez family said that there was a second weapon that was used from Kaylee Gonzalez. Can you confirm that?
Out of respect for the families, that's something that you'll have to get from them. If they wish to share that with you, it'd probably be through them, not through us.
Okay, and one more question. You said that it seemed like he chose that house. There's no clues as to why he chose that house.
After working in Moscow for several years as Chief Dollinger, that area is frequented by many, many people at all hours of the night when college is in session. So what Darren and I have surmised is that perhaps it's the old hiding in plain sight. There's lots of people around. There's lots of vehicles around at all hours. It's not isolated where you'd be noticed. So that's where that comment comes from.
It does. And no, it doesn't make sense. And it's if you were in that neighborhood at all, it's a very complicated neighborhood. It's very closed in. But at the same time, there's everything from college kids to adults that live there, people that have full-time jobs, part-time jobs. So any one of us could come and go and fit in there. So. Right here.
DA Thompson, during the plea hearing and then again today, it seemed like your voice quivered a bit when you were either putting up the photographs or mentioning the victims' names. I'm just wondering about the emotional toll on that one.
Yeah, you're right. My voice was quivering. Y'all were in there. There's a lot of powerful emotion. The losses are almost indescribable. And maybe my filters aren't as good as they might have been 45 years ago when I started in this business. But I think you also saw that even Judge Hippler was affected and impacted by this. There is no easy way to remain stiff-lipped and dry-eyed through this kind of tragedy. There just simply isn't.
I'm sure you're not aware of this yet, but there was a photograph where they zoomed in on a picture that Bryan Kohberger had on the defense counsel table. And it was an image of a black heart. I don't know if you've heard this or if you've seen the image. Hearing this, your thoughts?
First, I've heard of it.
I'm going to comment on the black heart just because I've seen a lot about that as well. And so, of course, I have no idea why he had it there, what it was for, or anything like that. What I want to respond to is, I guess, this kind of perception that's creepy. And yes, perhaps it is. I have received art from my clients, things that they have made for me as a token of gratitude. I don't know if that's what this was, but that is a possible non-creepy explanation of it. As far as why it is black, it's not that uncommon that you only get pencil in jail. You don't get pens because pens can be taken apart and they have, springs and sharp pieces and things like that. So you get pencils. And when you have a pencil, everything you draw is going to be black. So I don't know about reading anything too serious into the black heart. But of course, I don't know. That's just my instant reaction to it.
I've heard of it. There is something I need to say though, real quick. This is a product of, I'm sure I'm getting old in my failed memory, but there's one other person I need to recognize, and this is very important to us because this was a key person that was going to take us through trial, and that's Josh Hurward, the former United States Attorney for the District of Idaho who left office and voluntarily joined our office as a special deputy to help us. My apologies for the oversight as I wasn't reading my notes correctly, but thank you for that little interlude. Chief? Yes.
I guess my question is for Mr. Thompson, since you're still up there, incidentally he was on crime. You said that it was your decision to accept this plea agreement. It brings finality, people die in prison, but Corporal Payne just said they don't know who the target was and why he targeted this house. Was there a reason why, as part of the plea agreement, you require Anna Taylor to have her clients sit down with you all and to answer some of these questions?
I think that Judge Hippler addressed that today very, very well. Of course, Judge Hippler addresses everything very well, we've found. The law does not give the court or us the power to require a specific factual allocution. And let me finish. And we recognize that. We recognize that we could have said, well, in order for us to move forward, we want a factual allocution. But I have to be perfectly candid. I don't believe that there's anything that would come out of his mouth that would be the truth. I don't believe that there's anything that would come out of his mouth that would be anything other than self-serving. And I don't believe there's anything that would come out of his mouth that would not further victimize the families. And so that just simply wasn't a factor. We made our decision based on our assessment of law and the facts. We made our decision based on being able to obtain accountability and certainty, not just for the victims' families, but for the communities and for the state. And that's where our obligations go. In the end, and the old Harry Truman thing, the buck stops on my desk. Well, that's what I got when I was elected prosecutor 33 years ago. I never dreamed it would involve something like this. But we don't shirk our responsibilities just because it got big and nasty.
So that's the explanation. Okay. That's the explanation. Nothing that he would say would be true. Nothing that he would say would be, it would all be self-serving, and it would re-victimize the families. So I got some serious thoughts about this. Okay. Because number one, it is absolutely routine and normal for there to be, for example, cooperation agreements. Somebody gets a plea deal in exchange for testifying against somebody else, providing information against somebody else. That's normal. Okay. It happens all the time. It does not require that the plea be conditioned on, like, you have to stand up in court and say it at sentencing. If you're concerned about him re-victimizing the families, it doesn't have to be in that context at all. In fact, I don't think I've ever seen a deal where, like, that's the deal and that's the context. You have to make a specific factual statement at sentencing. Like, no, it's about providing more information so that there can be greater understanding of what happened. And the fact that he invokes this idea that the resolution was going to bring certainty without something like that. It just, I feel like he's not in touch with the problems of his own case. Okay. The limitations of his own evidence, why the questions are out there. And I just struggle with this. I don't like to bash prosecutors too much. Okay. I realize I do kind of do it a lot. And of course there are plenty of good prosecutors out there. Okay. All of my disclaimers and qualifications out there. However, it just seems unfortunately common, that prosecutors often just don't have the ability to see outside of their own perspective. One of the things that is kind of gospel in law school is that if you cannot see both sides of an argument, you are not going to be a very good lawyer, because you need to be able to anticipate, what is my opponent going to bring to the table? Can I diffuse that before they even get up to make their argument? If you cannot predict, if you can't anticipate what the problems with your case are going to be, you're going to be caught off guard, and you're not going to be nearly as effective as somebody who can see critically at my own case. Here's what the problems are. If he really thinks that a plea deal based on this information is giving us certainty, I don't think he has a good perspective on why there are questions about his case. I just don't. Like, yes, it's given us finality. We've talked about that. It's pretty final. Waive the appeal, extremely limited pathways, post-conviction, almost certainly off the table, because he, have I been saying Anders plea this whole time? It's Alford plea. I just realized that. Anders is a different case in Washington. Oh, man. I didn't do an Alford plea. You know, he admitted he did it. So, like, pretty much anything you can come up with, it's going to be harmless error. It's not going to be a manifest injustice because you said you did it. So therefore you got the consequences that you deserve. Essentially the view there. So we got finality, no question, but certainty without having questions answered. This feels very gaslighty to me. It's either gaslighty or just an inability to critically look at his own case. Now, let's talk about some logistics here and how this type of thing works. Because yes, if you're worried about him victimizing the families, great. Then don't make the condition that he say it for the first time in open court and sentencing. That's not required. You can make pretty much any condition of a plea agreement that's not, like, you know, contrary to public policy. Yes, you could absolutely make as a condition of the plea agreement, which he saw the reporter was going to challenge him on. I can't require a specific factual allocution. He saw she was going to challenge him on, yet you can make a plea agreement contingent on providing information. Absolutely, you can. Well, it would all be lies. Well, here's the thought. Here's the thought. Require verifiable information. Okay? If you require like a detailed description of how and why he committed the crimes, a lot of that, it's going to be verifiable. And so you will know. No, this can't be correct because X, Y, and Z. It doesn't comport with non-public information, you know, or whatever. It's just not viable. Self-serving, I mean, we talked about that already. Of course it's going to be self-serving. His explanation right here is self-serving. That's how people are. People have egos that they try to protect. They try to put themselves in a good light. We all do it. We all do it. So I remain highly dissatisfied with his answer. Highly dissatisfied with this answer and with this decision, because I'm still left with, what did you get out of this? What benefit did the state get out of this plea deal. You didn't have to go to trial. Okay. So is it a money thing? Are you saying there's a cost? A price on the justice that these victims should get? Pretty sure that's not what you're saying. Well, there would be the uncertainty of perpetual appeals. Okay, to some extent, but if you ran a clean freaking investigation, you don't have to worry about decisions being overturned on appeal, do you? I just remain concerned about what's the driving consideration here. I mean, from the outset, we knew this was going to be a death penalty case, because if this case is not a death penalty case, what case deserves the death penalty, if not this one? Why is it taken off the table? Because at the end of the day, that's what he wanted, and he gets to make that decision. Highly dissatisfying to me, and I can understand. I understand the Goncalves family in particular doesn't like that decision. I get it. I get it. It was leverage they had. They could have gotten information, and they chose to simply give it away. And I do. I remain baffled. I remain baffled.
Thank you. Corporal Kane and Lieutenant Burleson. First of all, I want to say to you, Corporal Kane, that the chief of family told me that you called them every night during that nearly 7-week manhunt, even though you didn't have to. And I just think that goes to show that there's some truth in this. So, that being said, I'm curious as to where you think or believe the murder weapon is, where you think or believe the clothes Kohberger was wearing that night are, and how do you think he avoided forensics?
Well, I can just tell you, and forgive us if we go back and forth, it's just kind of how we roll. But there is no evidence that we found that would lead us to any specific, even general location as to where the murder weapon or the clothes have been. And we searched. I mean, the FBI, again, to their credit, we had folks doing soil samples and so all sorts of things to try to come up with somewhere to start searching for these things, and we just never found it. As far as the forensics piece, I'll let Darren speak to
that. Yeah, and on the weapon, it wasn't a lack of trying. Everywhere that we had evidence of where he went, based upon phone records, based upon the evidence that we had gathered, we searched that. We went there. We did searches on the ground, in the water. We did searches. We sent soil samples to try to figure out maybe where a shovel had been used. So we searched everywhere that we possibly could, but the reality is we're looking for a singular small, it's not that small, but K-bar knife, and that's it. So
I got an idea. Hey, I got an idea. This. Let me just put this out there, okay? If you had a situation where maybe, like, I don't know, you could take the death penalty off the table in exchange for verifiable information. I don't know, maybe like where the murder weapon is. Maybe that would give you a clue about where to search and how. Just gonna put that out there.
It's in this of where it could have been, and we just were not able to find it. So
what about the clothes and his ability to avoid forensics at the scene, in a murder scene where we now know Kaylee Goncalves was stabbed 34 times and then another victim was stabbed more than her?
Right. So the reality is that somebody can carry this out and still not get covered in blood. That's the reality of it. And this does happen. And there's plenty of studies of that. And we've had some of the world's experts that we've asked those same questions because we've struggled with that. Of why do we not find more here and there? And the reality was, if somebody has the training, if somebody has thought about it, if somebody wears the right type of clothing, that could be the outcome. And that's what we were left with.
This is exactly the kind of thing that, I think a trial would have been so helpful for, because great. It's nice that he says that he's managed to convince himself that, that's possible. I still have a million questions. Okay. Cause I just don't buy that it's going to be that easy. I really don't. We've heard all kinds of, possible explanations. Okay, he wore a protective suit and booties and things like that. Okay, and then where did he take them off? Just by example, where did he take them off? Okay, in the house, because there's no blood trail out of the house. If he's in bloody protective clothing and he walks out the house, surely there is going to be a blood trail. Okay. Surely at least like drops, if not, footprints and stuff like that. So takes it off in the house. Does that not kind of defeat the purpose of the protective clothing in the first place in terms of like preventing transfer of stuff? Like, don't lose your hair, your trace DNA, your skin cells, etc. We know he would have had to have taken it off in the house because what Dylan saw was not somebody in protective wear. I would have liked to have seen this vetted. There have been studies about it. Okay. I'd like to see those. I'd like to have an expert on the stand, talk about that, name that. Help me identify that. How exactly that's going to work. You have at least one victim who resisted, fought back, but no apparent injury. Certainty we were supposed to get by this deal. Certainty. It's just this to me is a lot of trust me, bro. Trust me, bro. It's totally possible one person could have done all of this in the 7 minutes or whatever it is that the timeline ended up being to fit with the movement of the car and the sounds and the DoorDash and all that. Trust us. But I don't trust you. You're the government. It's your job to prove things. Would have liked a trial on this a lot. I can't say it's not possible. I don't know. That's the whole point. That's the whole point. I would like to know your basis for saying, yeah. Troubled us, but we were able to resolve it in our own minds and we're satisfied it was doable. Well, I'd like you to walk me along that path of how you reach that conclusion, because to me, it still seems kind of implausible. Very hard to believe.
Over here.
Gina Soares with CNN. Mr. Thompson, did you do psychological testing on Bryan Kohberger? Did that weigh into your decision to have a plea deal? And the stabbings, multiple stabbings are very personal. How did you assess that mode of murder?
I can tell you that psychological testing was done for Mr. Kohberger. The results of that do not rise to a defense to his conduct under Idaho law. The results of the various testing, most of it done by the defense or on behalf of the defense, it's also sealed by court order. So I can't speak to any specifics, but I can tell you, yes, psychological testing was done. I can also tell you that no, psychological testing or any potential psychological condition, Mr. Kohberger, that did not play a role in our decision.
Bill, does it have any bearing on where he will be placed or housed?
Where Mr. Kohberger, where the defendant is going to be housed, is going to be up to the Idaho Department of Correction. And that could very well change over time. And the reality is we will know about it after it happens.
Over here.
Did you monitor Mr. Kohberger's communications while he was incarcerated? And did he say anything that was helpful or gave you any insight as to why he did this?
Yeah, we did monitor it, both while he was housed in Latah County and then once he was moved down to Ada County. We have hundreds, thousands of hours of monitoring that was done, but there was nothing of evidentiary value that was gained from any of it.
Will you be releasing those conversations?
That's a good question.
It's my understanding that the jail will not be releasing things that involve personal conversations with third parties. That ultimately would be a decision because the recordings are possession of the two correctional facilities or detention facilities. But I'm pretty certain the Latah County Sheriff's Office policy does not allow for that. And I would guess Ada County is similar. You can ask them.
Back here.
Thank you. Greg Fisher with CBS News 48 Hours. Was there any evidence that Kohberger was following the social media of any of the victims?
So, trust us, we wanted that to be the case. We've looked for a link and we have not found one. Not one.
Yeah, through the entire investigation, I think that's something that we need, that you want, is to help to understand this and say, well, what's the connection? What was the link? And so we had every resource possible, and we worked that tirelessly, both from everything from his side, but all the victims and all the members of the house from their side. So we have never, to this date, found a single connection between him and any of the 4 victims or the 2 surviving roommates.
And I just have a hard time, again, with how we are supposed to have certainty here with this. He didn't know them. He didn't go there. But just randomly some night he went to a house he'd never been into before and went in and killed people. Is it possible? Of course it's possible. Of course it's possible, but it sure seems implausible, doesn't it? It seems quite implausible. And so when you had the opportunity, the potential to get some answers for that, I just don't understand why you wouldn't take that opportunity. I just don't. And if you don't believe it, you don't believe it. But again, you can get verifiable. You can get verifiable stuff. I think again, the biggest concern in all of this is look. Yeah, we're buying. He did it. He said he did it. Okay? He said he did it. If we don't know why he did it, then I'm not sure that we know if everyone who is responsible, is he alone? He never said I did it myself. I'm the only person that's responsible. Would really be nice to rule that out because that seems like a plausible explanation for why would this guy who doesn't know these people and has never been here before show up at their house and kill them? Because there's an accomplice. Why would there be unknown, untested male DNA that does not belong to Bryan Kohberger in the house on the staircase? Because there's an accomplice. These are plausible explanations, and there's nothing wrong with asking those questions. Now, no case is ever going to be able to tie up every single little loose end. There's almost always going to be there's going to be conflicts in evidence. It's just natural, okay? People don't have perfect memories. Sometimes there just are things that may not be able to be explained, but this is a lot. This is a lot. It's just a lot of holes.
Michael Ruiz from Fox News Digital. My question is for the investigators. You guys are going through this case. You've got a lot of evidence about his background, his education, his training. You said earlier you couldn't identify a reason the house was targeted. Do you have a motive for this?
We don't.
Lauren Patterson, Northwest Public Broadcasting. This question is for Anthony Gallagher, actually. I remember when Anthony was a beat cop assigned to talk to us at the very beginning when all of this happened, and now you're running the show. So I wanted to ask, as a community member, has this case shaped and changed how you're policing in Moscow?
It's changed everyone involved. How could it not? It was a devastating tragedy to our community, and our police department is a part of that community, and it was very difficult for us as well. So, this is just one of those things that will not define us, but it is certainly a part of our history that we will never forget. Yes.
Rebecca Finn, Associated Press. The perhaps unprecedented level of interest in a court case like this in Idaho was matched by an extremely high level of secrecy within the case. The Gonzalez family has said that they're desperate for answers about what happened to their daughter. Do you anticipate most of the court documents being unsealed, or are there things that you will specifically request remain sealed?
As far as the court documents, Judge Hippler has told us that he is going to work with the attorneys to go through every sealed document. Probably most of the documents were sealed for the purpose of protecting against tainting a jury pool. And those documents I would expect would become unsealed. Requests for discovery, various things like that. There are also documents in there that contain very personal, private information regarding victims and families. I expect those likely will not be released under Idaho's protections against what the law calls unwarranted invasions of personal privacy. I realize that can be frustrating for folks who want to be able to explore this thoroughly, but we have to balance, and the law balances, the privacy of the people who have suffered, including the victims who are dead, with giving the public as much information as we responsibly can.
I'm just wondering, did the lack of knowing the reason or the motive concern you when prepping for trial? Because juries tend to want to explore the motive or reason for a crime. And also, how do you as investigators and attorneys grapple with that? Because if you can't rationalize something irrational, then how do you continue knowing that you won't get an answer?
Well, I tell you, from an investigator standpoint, we already know and realize we often don't get to know that. We want it. We all do. We naturally want that. But the reality is it's not something that we have to have or that we get. And the reality also is that oftentimes those very things that you're asking about, they're only known to one person. And it's the person that commits those crimes. And I think that's probably what we have here.
And I would add that going through this whole investigation, I'd probably say it's easier than it was for Bill's offices. We were focused on a task. We had a task to do, and it was discovering evidence and interviewing folks and that sort of thing. So the motive necessarily doesn't play a part in that, right? Obviously it can, but we were just focused on getting the job done in the correct way as best we could. So.
And from the prosecutor's point of view, yeah, certainly lack of a clear motive is something that we think about and consider as we're preparing for trial, because we're going to have a jury of 12, ordinary, honest citizens there who wanted to figure this thing out. But we also, and I've also found that juries tend to follow the law. And even jurors who come in with strong feelings, they tend to follow the law that the judge gives. And there is no element of motive in Idaho law for murder. And so we set that aside as something that we were going to dwell on. Whether there was clear proof of a specific motive, because we knew it wasn't legally required. And practically speaking, we knew it wasn't something that we possessed that we could give to the jury without speculating. And I'm sure as heck not going to stand in front of a bunch of 12 jurors and start speculating. We're going to give them the evidence. And the evidence in this case, what you heard at the time of his guilty plea back on the 2nd, that evidence was compelling, and it showed his guilt without having to worry about motive in a human sense. Thank you for the question.
Compelling. It's marginal. Okay, it was going to get him convicted, especially with a death qualified jury. The DNA alone was going to get him convicted with a death qualified jury, but then you add in the Amazon stuff. He was going to get convicted. But compelling? No, this is marginal.
Did he say anything when he was arrested?
Yeah, so Brett and myself and members of the FBI, we traveled back to Pennsylvania. We were there, and I know they hit on it earlier, but I'd be remiss without talking about the cooperation and the support that we had from them was absolutely incredible. From the time that we got on the ground with the Pennsylvania State Police and with the FBI back there, it was unbelievable. Anything that we needed, they were there to facilitate it. So we helped to shape what that looked like, what the arrest looked like, what took place once they hit the house on the search warrant and he was taken into custody. Brett and I were at another location, a barracks of the Pennsylvania State Police. And then he was brought to us and we conducted an interview with him that night there in Pennsylvania. So
Talk about what he said.
So we went into this interview. We used a lot of influence and guidance from the FBI and their behavioral analysis unit. They helped us a ton in framing our our interview strategy, rather. When we spoke to Mr. Kohberger, we kept it pretty surface level to begin with. The idea being get him to speak and keep him speaking. It was pretty surface level. And then when we tried to get into things a bit more detail, he decided to end the interview. So that's pretty much.
As soon as we tried to walk into the purpose of why we're there, which obviously he knows we're detectives from Idaho. So that's when we really started to shut down and they just shut it down. So
calm, relaxed.
Say very similar to what you see and whenever you see him in court.
Okay, next question. Yes, sir.
Yeah, Mike Baker, the New York Times. I'm wondering if you can talk about Mr. Kohberger's family, whether you got much cooperation, tips, input from them along the way.
The only thing I'm really able to talk about is that we didn't get any tips or any evidentiary items from the family. So, anything to add to that?
No.
Yes.
Just wondering if you ever had any idea of what would make Mr. Kohberger take the plea deal yet?
No.
Can I ask a follow-up? I know the report.
That was a short answer. You probably have time for a short follow-up.
Can I also ask a follow-up to the investigators? I know there's some reports that there was a piracy for container out of the house. Did you ever determine what that was?
No, and the belief was in the once driving roommates in her statement, and that's out there, was that she observed something in his hand when she saw him, but we don't know what it was.
You had an expert who was going to testify about cleaning something off of his work computer. Is the software experts. Was there any evidence that he had tried to wipe anything from his phone, software-wise? The barn parts, I believe, is the name.
Yeah, and so this kind of goes into the connection to the victims as well. That's a similar question. We had the world's foremost experts on this look into it, and there was evidence that he had used software to wipe many of his devices relatively effectively. So there wasn't much evidence obtained after that.
Including, I think he had two cell phones, or was it just one cell phone?
I think he had one active phone, but I don't remember, so don't quote me if he had more at his home or office or somewhere else.
Just the work computer that he didn't wipe.
Yeah, he regularly used software to try to wipe, clear things off. He used VPN on his devices also.
So I got to tell you, this actually kind of raises a little bit of a more question for me, which is, if part of their evidence is he was deleting Amazon search history, was that him? Was that his software? I don't know. Search history seems like the kind of thing that if you're concerned about your digital privacy and you're trying to conceal that type of thing, make that type of thing not generally available. Yeah, you'd be trying to get rid of search history. Is that something a software program would do? I really don't know. I've never had software to wipe my phone, clean out things like that. No idea. See, details. Details would be really helpful to help us understand the big picture.
Back here.
Kevin Fisher with the Idaho Statesman. I'm hoping you can walk us through the decision to hand off the DNA process on the knife sheet over to Offer Labs, who's contracted by ISP, and then ultimately the FBI takes over that IgG process. And then Prosecutor Thompson, I'm curious if you had concerns about constitutional rights issues based on how the FBI conducted themselves in that part.
I'll start and I'll just speak briefly to, when we were notified that we had a DNA from the knife sheath, and it was a single source male DNA, touch DNA, then we knew that we had capabilities to take that further. So you're correct, the Idaho State Police has a contract with Othram Laboratories in Texas. So we flew that over there and they started the process of working that and what was the beginning of the IgG process. And at some point during it, we were working with the FBI, which we did closely throughout the entire case and every aspect of it. We talked and met with them and they had further resources and some capabilities that we thought may get us somewhere quicker. And so we made the decision to then shift that to the FBI and continue that process there.
And as to your question about legal concerns, my simple answer is no. I didn't have legal concerns about how the FBI conducted their IgG investigation. I know that was the subject of lengthy, detailed, painfully detailed motions and briefing, and Mr. Nye rose to the occasion and was able to address all of that. But in the end, it's simply no different than sending somebody undercover into any place to gather information. And I was not concerned about the legality of it. And the judge came through and made the right decision that there was no violation of the defendant's rights or anybody else's rights.
That, of course, is not accurate. That is not an accurate statement. The judge did not, in fact, make a determination that there was no violation of anybody else's rights because that was a standing issue. In fact, Mr. Thompson, that was the defense that your office raised, that even if the FBI had violated the rights of millions of people who had submitted their DNA into these various databases and restricted law enforcement access, and law enforcement still went in there in this investigation and got it, as there was testimony to that effect, Bryan Kohberger doesn't have standing to invoke other people's rights. So other people's rights, not at issue in this case or in the litigation. There was no such determination. And the attempt to rose color that, I mean, look at his face right here. I just happened to time it at the right time. Okay, a little smug look there. That ain't what happened. And he knows it. This is what part of continues to raise concerns for me about why this deal in this format, what's the benefit, and so forth. It's stuff like that. I don't know what was painful about the detail of the motions. Was that painful? The FBI's malfeasance? The IgG investigators' malfeasance in that case? It came out in the motions in limine. They backdoored access to personal, highly detailed genetic information of individuals who had not consented to it. That happened.
Had he not left the knife sheet behind, would you have been able to track him down?
We've talked about this ad nauseum. The answer is yes. Through the car, most likely. We had some amazing people going truly line by line over tens of thousands of white Hyundai Elantras. So we believe we would have got to it through that avenue. The time frame for that is uncertain. It could have been a week later, could have been 2 months later. We just don't know. We would have found it. We would have found it.
There's a lot of questions in regards to that initial window. Brett and I made the decision on what that window was, even though the experts were saying there may be more years that match it. But the simple numbers that we began to look at were astronomical, of thousands and thousands, tens of thousands of these vehicles. So we chose to try to narrow it and start smaller. And then as we had to, we were going to open that up. But we both believe we would have gotten him through the car eventually.
A question for Mr. Thompson. Amanda Rowling was trying to, it appears that the plea deal, it felt a bit rushed. So the question is, why did it happen so quickly, considering some of the families were against it? And also, the Mogan family at the plea hearing mentioned saying that this is the best possible outcome. I'm just wondering, do you agree with that, or would you like to see a different outcome?
Well, I think we agree with the Mogan family. Our decision was that this is the best possible outcome, all things considered, and factoring into that, that the defendant was prepared to plead guilty as charged. Now, if that hadn't been a factor, we'd be picking a jury for trial starting right now, or starting this week. What was the first part?
Why was this such a quick, it felt rushed, so why did this happen so quickly to the family?
No, I hear you. The process moved quickly. There was no doubt about it. And like I outlined for the court earlier today, things changed dynamically the week following the June 18th hearings on the defense motion for a continuance and the alternate perpetrator motion, where Judge Hippler made it very clear that the defense was not going to prevail on either of those. And so the reality of trial was there, and there was nothing else in its way. We were continuing to prepare for trial. We had been doing that for months. And as I mentioned, that's me bringing Mr. Hurwood in to help us because the Attorney General's office was not able with the manpower to help us all the way through trial. We were ready to go. When we were approached by the defense about the possibility of a plea, our first question was, is your client prepared to plead guilty? And it took them a little while to give us that answer. In the meantime, we reached out to the families and we talked to the families and we solicited their input. And we considered that in making our decision. The fact of the matter is, and I think Judge Hippler commented on this back on July 2nd when we were in court, is that the logistics of the upcoming trial with 10,000 prospective jurors being summoned in, the court staff making arrangements and preparing to process that part of the case dictated that if the case was going to resolve, it needed to resolve quickly. And so that kind of drove the pace over that weekend, the last weekend of June. At the end of the weekend, when we understood from the defense that the defendant was prepared to plead guilty, the court was notified the next morning, and the court wanted to move quickly to get a plea done on the record if it was going to be done, and if it wasn't, so we were not interrupted in our trial preparations.
What he's saying here without saying is that they did it quickly so that it wouldn't fall apart. They didn't want him to get cold feet. They wanted to nail it down. And that happens. It's not uncommon at all. You know, people sitting in jail can be very indecisive about what they want to do and what's in their interests and so forth. Sometimes somebody has a long talk with their lawyer and they decide, yeah, it's going to be in my interest to plead guilty. And you go and you set the whole thing up, and then they go and start making phone calls to, you know, family and friends and other folks, you know, some of whom, yeah, I hate to say it, but can be part of the reason why the person is sitting there in jail in the first place. You know, not necessarily really helpful input. Talk them right back out of it. Happens all the time. So they wanted to nail this down. That's That's the quiet part he's not saying out loud. There was a risk that if they didn't do it fast, it might not ever happen. And they really wanted it to happen. So they made sure it happened within like 48 hours.
Were the main concerns, as Judge Hitler had said prior, right? With the jury as a factor.
Yeah, the practical aspect is that the trial machine was running. And if it was going to be interrupted, that had to be known as soon as possible. I think that's the fairest explanation.
Okay, question here.
Michelle, thank you for 48 hours. I just had a question about when you're looking into Kohberger's past. Is there any early signs of trouble, or what did his background look like?
Well, we can't go into his younger years. I believe that's actually still under seal. Correct me if I'm wrong. But what I can tell you is the things we do know about him was that his education led him down a path that was very much focused on forensics, crime scenes, that sort of thing. So that was really what we focused on in his background, is what led him down this path. How may he have prepared for this? And I think that was a big component of that, was just his schooling and his choice of potential future profession. So.
And just so there's no speculation here by what Detective Payne just said, documents under seal involving Mr. Kohberger's background, they may or may not be released down the road. I can tell you that there is no evidence of any criminal history of any significant nature. There was no evidence of a history of violence. There was no evidence of a history of a factual predisposition to do the crimes that he committed here.
Really important here, guys. Really important point. No prior bad acts. Okay. So rumors about like there's something about like he broke into somebody's apartment or something like that. Rumors that like he killed someone's dog. False. Okay. False. No, that's what he's telling you here. No indication of any kind of predisposition to do something about this. And I just want to highlight once again, that is not what psychopathy looks like. Okay? That is not what psychopathy looks like. Antisocial personality disorder. Let's just, boy, can we just pull up the DSM? Let's just pull up the DSM, for heaven's sakes. I'll do it in the background since we're watching this. Failure to conform to laws and social norms, deceitfulness, impulsivity or failure to plan ahead, irritability and aggressiveness, reckless disregard for safety of self or others, consistent irresponsibility and lack of remorse. That's what psychopathy is. And it's like, you don't have the planning. This is like a planned thing. He went to school so that he could do this. Like that is not consistent with psychopathy. Going to graduate school, like being able to even get that far in life, not consistent with psychopathy. Again, the failure to conform to laws and social norms, that's one of the most like common ones, one of the most prevalent ones. Like when I'm getting a client, I've had a few clients that get assessed for whatever reason and it comes back with antisocial personality disorder. And that's almost always like the check the box criteria. That's just easy because they have a long rap sheet, like going back into juvenile days. Long history of disregard for rules, norms, rights, problems in school, etc. There is no history of anything like that with him. Okay. Very important fact.
So if there are any concerns among your listeners or readers that somehow he was a serial killer in waiting with all these prior actions, we are not aware of any behaviors like that that preceded what happened here in Idaho.
We'll take this question here, and then we're going to have two more after that.
Yeah, I'm Heather Harden with CBS News. Questions for Mr. Thompson. Mr. Thompson, you talked about the individual's families before the plea deal was reached, including Goncalves. Have you spoken to the Goncalves afterward about their displeasure with this? And if so, what is that conversation like?
We have spoken with families afterwards, and I can tell you that families that did not agree with our decision have made that very clear to us. And I don't expect anything different. I respect, and we respect, that everyone is going to grieve differently, even within family units. And everyone is going to look at the case and possible resolutions from their own light, and they are entitled to that as victims. I'm not going to pretend that everybody was just fine with our decision, because there were families and family members who were not. And we accept that. We recognize that. It's just a fact of life.
2 more questions? We've called on you yet?
It was stated earlier that the target is unknown. However, it's been speculated that the convicted may have encountered Maddie while she was serving at Maddie restaurant due to the vegan menu options. When digital data was analyzed, were there any location pins or any information there that could have connected him to where Maddie worked?
No, there wasn't. Like I said earlier, we wanted that. We looked for it in every possible way, digitally, financially, physical location, anything you could think of, anything that we thought, where is the connection? Where's the overlap? And we searched tirelessly and never found it.
Was at that restaurant.
I can't say that he was never there at all, but we never found any evidence at all from interviewing everybody that we possibly could, talking to every person that would have that information to be able to show that he was there or that there was a connection through the restaurant.
Okay, last question here.
That's also consistent with the owner, I believe, when rumors had first started to come out that that was the connection, was through the Mad Greek. The owner had made a public statement that they had no indication that he had ever been there. Of course, that doesn't get reported nearly as widely as the rumors do. In fact, I'm pretty sure, did this Mad Greek rumor get picked up in the most recent documentary as well? I think it might have. So yeah, guys, a lot of what is out there is people's perceptions of, oh, this is an overwhelming case. This was so much evidence. It's clearly, crystal clearly him and only him. It's not based on anything that's known. It's based on a lot of fiction. A lot of fiction was reported as fact in this case, and it's very unfortunate. It just speaks to the blurring of the distinctions between journalism, gossip, and propaganda that we have in the modern world. Information has just become another tool, another asset, another way to be able to control people through information. A little bit scary.
Okay, just 2 follow-ups to earlier questions, if that's okay, so I can make sure we're understanding everybody correctly. First of all, Mike's question about the family. You said that you didn't get any evidence from the family. Was there any hindrance of the investigation from the family? And was there any specific evidence you were hoping to get?
Are you talking about his family, Kohberger's? Yes. There was not any hindrance, anything, nothing that impacted us carrying out the investigation.
Great, thank you. And then the second follow-up, when you mentioned, obviously he'd follow this line of interest in his studies, did anything in your investigation indicate that was chosen as part of a planning process as opposed to just an area of interest?
There was nothing aside from, we have some of his coursework where he did, a crime scene recreation, that sort of thing, but it was all part of his studies. So I don't think that any of us attributed that to a planning process per se. Certainly it was a learning process, but whether or not it was a planning process ahead of what he did, we'll probably never know that.
Yeah, and I would say we didn't find anything that would be any different than a student similar, a different student in the PhD program.
Gotcha. So then I'm understanding that the planning process, that your investigation turned out, if it was part of the plan, was maybe that purchase of the K-bar knife on Amazon would have been the first, step toward.
Yeah.
Did he plan it? Did he buy it with the purpose of that? Is that what you're asking?
Yeah.
And we don't
have
know.
anything to show or prove that he did that.
Thank you.
Okay.
Well, thank you all. That concludes our Q&A section.
That concludes the Q&A session. And, once again, with just more of what they did not have. Okay. More of what they did not have. They did not have, any indication that, he had like special knowledge, but did like special research into how to commit a crime like this based on his studies. He had, apparently pretty normal, interest in and entry into criminal justice as an academic field. I mean, if the purpose the purpose of this press conference was to help share with us some of that certainty that Mr. Thompson was talking about, I don't think they pulled it off. I'm gonna grade that like a solid D-. Don't feel like there was a lot of certainty that we got from that. So where does that leave us, guys? End of the day, what's the takeaway here? I'm going to get to your comments and questions and stuff after this, but I'm dissatisfied. I am. All of the hope that there was going to be more evidence that the state had that they just hadn't, brought forward for whatever reason. I knew that was kind of silly. But I did expect there to be some things that had developed over the course of the investigation since the time that he was arrested, since the gag order was in place, that we wouldn't know about. But it turns out there's not an awful lot of that. Not a whole lot to add. So it's unsatisfying. There's enough evidence there to think that he did it. Certainly, he was going to get convicted. Said that multiple times. The DNA was going to convict him. The Amazon searches, if the DNA wasn't going to be enough, the Amazon searches were going to get it done, because it takes the transfer DNA argument off the table. If he's got a knife sheath, what's the odds that it's some other random knife sheath that has his DNA on it that ends up in the bed with 2 murder victims? Just seems a little bit more plausible that, well, that's because it's his knife sheath. You better have a pretty good explanation for what it's doing there, other than you brought it there. He says that he did it, and I'm not going to argue with him. That is a clear takeaway from the guilty plea process. My review of this, nothing precluded him from doing an Alford plea. He didn't. He took a straight up plea. But it's unsatisfying because, yeah, of course, you never understand the ununderstandable. And some things, I feel like there's maybe a little conflation between understanding something and like justifying something. Again, like, of course, nobody is ever going to say murders like this would be justified or excused, or they're okay because, or it's not that bad because. Like, yes, it's extremely bad. It's like the worst kind of thing that can be done. But you can understand why. And it's not a bad thing to want to understand why. It's part of, from my perspective anyway, just appreciating what these victims went through. Part of getting justice for them is doing the best we can to try to understand the ununderstandable. And so I'm dissatisfied because I feel that there are still so many questions that This plea deal doesn't resolve. I'm particularly dissatisfied because it seems to me they had ample opportunity and leverage and ability to try to get at least some more answers to some of those questions. And they didn't. They didn't. They just gave that away for reasons that remain really unclear to me. I don't know what the prosecution got out of this deal. I don't know what they got out of it. So I understand the families of the victims that are not happy with the plea deal, think there should have been a trial. I agree. I really agree. Not because, I think Bryan Kohberger is innocent and he would have gotten off. No, I think he would have been convicted. But I think the vetting of all of this information in public and so many of these assumptions and explanations that the state has been willing to offer, to be able to test that and understand the basis a little bit better. Because it's not wrong. It's not wrong to look at a crime like this and look at a theory of how it was perpetrated and have questions. There's nothing wrong with that at all. Particularly when it relates to issues of are we absolutely sure that this is justice? Are we absolutely sure we got the guy, we got the only guy, and that therefore the threat has been eliminated. The danger is off the street. Just feel like that's really hard to know with where we sit here today. So it's final, it's over, and we may never get those answers. There has been a massive document dump, of course. We talked about that right up front. So there's a lot of information to go through now, all of the MPD reports. I have started going through those. It's, large volume of stuff, gonna take a while. The contrast, I will say the contrast between this case and Karen Reed's case when it comes to documenting the investigation. Wow. Okay. Like lots of minute details have police reports here in the case. And that's part of why it's so extensive, all the documentation. So that's normal, guys. That's normal. That's how you normally investigate a death, with lots of documentation, record keeping, and so forth. But anyway, possible that there, might be some clues in some of that, as far as why police made investigative decisions that they did make. But at the end of the day, I'm still left with that concern that the defense raised early on in the case, that this looks like tunnel vision. And it doesn't mean that they didn't get the right guy. But it definitely raises concerns, not just for did we get all the answers that we need to really make sure that we have justice in this case, but also how are these guys going to investigate stuff in the future? Are they going to take that same attitude? What if they don't get the right guy next time? It's concerning. So with that, guys, I am going to turn to your questions and comments now. See what you guys have been thinking. Joanna Wren 2. What do you make of the defense team expressing Bryan Kohberger's innocence so seemingly strongly? Thank you for your take. I think they sincerely believed it. I mean, I said at the time, it made an impact on me, because that's not the type of thing that you say lightly at all. At all. You don't stake your credibility with the court on something like that frivolously. I know a lot of people are like, oh, it's the defense lawyer's job. Their job is to say he's innocent. It's their job to say, you know, the prosecution has the burden of proof and whether or not the prosecution has met it. It is absolutely not their job to assert a personal opinion about innocence. They're not required to do that at all. In many ways, I could argue that's kind of frowned upon. So I think that they sincerely believed it. I really do. The question is, for me, did that change? I don't know. We'll another question we'll never know. This one I have to be satisfied knowing that I'll never know the answer to because it's confidential. You know, the attorney's thought processes and impressions and opinions and things like that about the case. No, highly confidential. We will never know. Ann Taylor will never tell us. But I wonder that. Did their opinion change? I don't know. Said before, for me, the kind of really bad fact that I could see being the tipping point is the Amazon stuff, the K-bar knife. Okay, if he bought a K-bar knife, he doesn't have a K-bar knife anymore. It's a pretty bad fact. Pretty bad fact. Pretty hard to explain. Where's your K-bar knife in the sheath? Where's yours, the one that you bought? Because it wasn't found in any of those searches. Very incriminating. I could see it being something like that, you know, especially if your client has never mentioned to you before that he had in fact purchased a K-bar, you know, something like that. Very possible. Duncan, Idaho. When I first saw BK's close together predatory eyes, I thought, oh, this guy definitely did it. Obviously not legally valid, but do you put any stock in initial hunches like that? I do not. And I would encourage you, it's old and dated now, but Malcolm Gladwell's Blink was a great book on like snap judgments like that. The problem with it is like, sometimes it's really good and you should absolutely pay attention to it. And sometimes it's absolute trash and you should completely disregard it. And the problem is you don't know which is which. Sometimes your hunch is going to be right, but sometimes your hunch is just going to be, you know, the product of biases and just personal experience, subjective values, things like that, that aren't necessarily that transparent to you when you're getting the hunch. So your hunch was right. Congratulations. But I don't know that in and of itself that that would speak to the validity of hunches in general. Problem is often hunches are wrong. The Squid, regardless of how Bryan's lawyers really felt, assuming Bryan maintained his innocence prior to the guilty plea, they did exactly what they're supposed to do. That's the kind of advocacy I'd want. That they did their jobs extremely well from my perspective. And I want to repeat that I think there is very much a public service here that was done by Ann Taylor and the defense team that is not being recognized and they won't get credit for, and that is the acknowledgement of guilt. That is not easy. Not easy to pull that off. Pull it off and still have your client happy with you in the courtroom. That is not easy. And that had a major effect on the finality portion of this resolution and taking the potential for post-conviction types of actions, writ of habeas corpus, stuff like that, takes it off the table because he admitted guilt. Claude Simeon. Is Andrew's plea always a bit, it's Alfred plea. I said that wrong. What am I even thinking? What did I say in Anders' plea? Oh, it's Anders' brief. God, that's what I was getting confused about. Yeah, it's an Alfred plea. And Anders' brief is when you're appointed appellate counsel and you like read through the record and you're like, there's nothing. There's literally nothing. Like they did everything right. I can't make a non-frivolous argument that there was an error on appeal here. So it's like this whole process that happens. I don't know why I had those wires crossed. It happens sometimes. Like I get older and more malapropisms. It's an Alford plea. Anyway, is it always available? It's up to the prosecution. They can say, I'm not going to accept an Alford plea. And that's part of the whole idea that you can condition, like, I will make this recommendation, I will do this, I will take this off the table, but you have to do X, Y, and Z. Some prosecutors care a lot. Some prosecutors don't care at all. I have had a prosecutor who was like, no, if your client does an Alford plea, it will be, it's a breach of the plea agreement. It needs to be a straight plea. I've had other prosecutors not care at all. Sometimes it may just depend on the case. So default is yes, it would be available unless there is some kind of restriction on you being able to do an Alford plea as part of a deal. There's nothing like that in this plea agreement. No chance. Judge said must plead guilty instead of Alford. So BK falsely pled guilty to avoid death penalty. You can't say why. I mean, again, I don't know. What I can say is that me looking at this process, this documentation, this plea hearing, all of that, there does not appear to be anything in it to me that would have kept him from doing an Alford plea if that's what he wanted to do. It wasn't foreclosed by the terms of this resolution. So he could have still maintained his innocence, and he did not. That's how I see it. Lucy Fair, is it possible he was precluded from taking an Alford plea during talks before the written agreement was finalized? Only way the state would deal. Theoretically, but if it's not in the written plea agreement, it's not really part of the deal because you don't have any way to enforce that. It also go back to the rule that we looked at in the beginning, where it talks about the plea process and the nature of kind of what has to happen in court when there is a plea agreement, and it has to be put out on the record, and any types of conditions and benefits and things like that, they have to be spelled out. So if this was going to be a condition, it needs to be on the record in one form or another. So you can't rule out that there was a gentleman's agreement behind the scenes, handshake kind of deal, and everybody sort of understood that, he's gonna have to go in and do a straight plea, even if he really does continue to maintain his innocence. For practical purposes, it kind of doesn't matter. The legal effect is he admitted guilt. He admitted guilt, and that's going to kind of foreclose his ability to be able to assert innocence in any kind of meaningful way. Now, it doesn't preclude him from being able to make statements. People can say whatever they want, but like I've said a million times, talk is cheap, guys. Talk is cheap. So this is possible, but it just doesn't seem all that likely based on the structure of what I see. Z, FBI consulted Michael Easter on Kohberger too. He should have been allowed to testify for Karen. Did you see Lally testify this week? Proctor will too. I did see Lally testify. Wasn't that ridiculous? It's insane. Yeah, the next hearing I think is August the 5th. It's coming up pretty soon. So they haven't finished with Lally. He was never crossed. Proctor was supposed to be there apparently, but didn't show up. So he may be there at the next hearing. But basically, 3+ years, Adam Lally has been sitting on, or had sat on, search warrants and the supporting affidavits. 6 of them, I think, in total had been done in the case. And 3 of them he sat on? I forget the details now, but never disclosed any of it. And so he's describing like, oh, well, I have a list of things I have to follow up on. And all these times he asked Michael Proctor for it and you didn't get it. And what did you do to follow up? Nothing. He did nothing. He literally took the case. Like, Took the case all the way through. Never disclosed search warrant affidavits. This is a big deal. I'll tell you the red flag that it gives me. Now, I don't know. The search warrant affidavits have been turned over now. Prejudice is going to be part of the argument that Rosemary Scapicchio has to make here. That this is information that should have been turned over before trial. But what's the consequence? There has to be some kind of prejudice to determine what the consequence is. So, should there have been a motion to suppress filed, for example? I don't know. I don't know those details, but I would expect, Rosemary Scapicchio knows that because she's got the affidavits now. But that would be my big suspicion. Why wouldn't you just turn these over? Why wouldn't you turn them over? It's bizarre to me. The warrants are out there. They're public record. Everybody's going to know that they're there. The affidavit is the part that's the red flag because the affidavit is the justification for it. And, as we know from all these different cases, you mess up the search warrant affidavit. That's very, very common basis to challenge the admissibility of evidence that was derived from that search warrant. So the affidavit contains false information. The affidavit, is just requesting. It doesn't establish probable cause. It's requesting, stuff that isn't reasonably related to the circumstances set forth in the affidavit. There's a lot. You really need the affidavit to know if this evidence should be coming in at trial or not. And so to not be able to assess that is a pretty big problem. But so why would you not turn it over? I don't know. Maybe if there's obvious shenanigans that you engaged in the investigative process, I would expect, certain corrupt types of entities to engage in. Well, maybe then you'd have an incentive to sit on it for 3.5 years, because you're going to get exposed if it comes out. I don't know if that's the case, but I expect Rosemary Scapicchio will tell me if it is. EB gifted some memberships today. Thanks so much, EB. I really appreciate that. I don't know if I'll be doing a lot of content in the next month or so. We'll see. Like I said, I really had been so ready for this trial. I'd been all geared up to it. I had kind of front loaded my summer in terms of my plans and things I need to get done and stuff like that. And so now there's this time and this opportunity, and I'm not quite sure yet what I'm going to do with it. But we'll see. James Casatelli, it seems like going to trial was the better option. At least he could appeal if convicted. I think I'd have taken my chances with a jury with such a flimsy case. Waiving appeal is mind-boggling to me. I mean, yes, he can appeal, but as the saying goes, appeals are for losers. Okay. And it's hard to win appeals, guys. It is hard. It's hard to win appeals. You're very much on the back foot. The standards are against you. You got death on the line. That I mean, I get it. I do. Death is pretty serious consideration for making the wrong strategic decision. It's a big consequence. So I don't know. I really don't. I do think he was going to be convicted. Would it have benefited him to have the full vetting of the information? We'll never know. Maybe not. But I don't think, we'll never know because we don't have the counterfactual situation now where that happened. But waiving appeal really it adheres in a guilty plea. That's normal. That's normal. That's just part of the process, and that also, I mean, there's some policy kinds of reasons for that I think do make sense. It it wouldn't make a lot of sense, for example, if you could go ahead and, litigate your case up to the hilt and then plead guilty on the eve of trial and then appeal and then go back and challenge all of those, previous rulings for the purpose of just dragging out the time. Like if you get a new trial, okay, like maybe I've got a really strong issue. So if I plead guilty, I can appeal and I can win on that, and that'll buy me like another 2 years. And so maybe then in the meantime, evidence will dissipate, witnesses will get harder to find, memories will lapse, things like that. Time in a criminal prosecution rarely benefits the prosecutor. So I get that. There would be room for a lot of gamesmanship if that weren't kind of part of the requirement. But it's a difficult strategic decision to make for sure. Tough one. Z, why lady turn podium when Kaylee mom wanted to face BK? Is prison justice real? Ramsland befriended BTK and taught BK worth suspension and investigation. Well, so again, as far as the first part of the question, the victim impact statements are not about this being your opportunity to address the defendant. It's about providing information to the court about the impact of the crime. So it's really, it's not an appropriate use of the court process. Now I see, this is a controversial subject. I recognize that because yes, on the one hand, people get to grieve how they want. And I'm not going to criticize any of the families for anything that they say. I'm not going to do that. Everybody is different. Everybody has different processes. I might criticize how people respond to things that people said. People that are not grieving, that are clapping at like seals on the sidelines about some things that are said, I'll criticize that. But I'm not going to criticize the families. Yes, they also do have First Amendment rights to say what they want to say, but not inside a courtroom. Okay, your rights to speak inside a courtroom are limited by the decorum of the court and the process. You don't get to walk into court and just say whatever you want. It is not a traditional public forum inside a courtroom. So the judge and the legislature through their laws and so forth get to restrict the scope of what you get to say and do inside a courtroom. Is prison justice real? Unfortunately, yes, it is. Prisons are extremely violent places. Very violent, very ugly. There's a lot of collateral damage in the prisons. Yeah. Ramsland befriended BTK and taught BK worth suspension and investigation. No, there's no crime. There's no wrongdoing. She's not wrong for studying crime. That's her area of expertise. She's not wrong for teaching a student normal things that you teach in these types of environments. So she hasn't done anything wrong. She's not deserving of any kind of censure, in my view. V. Grave, did they ask if he admits to doing it alone? They did not. No, they asked him for nothing really factual beyond just here's the allegations in the complaint, in the information, the indictment. Are those true? Yes, he said yes. So that's the extent of the factual information that we got. He went, asked, did you stab all of them and cause their death? He said yes. He said nothing about doing it alone or any other aspect of the circumstances. Claude Simeon, people like kid you repped as juvie and adult, mental health problems that would have been in sanitarium decades ago. Are we really better now than then? Some of these issues are just always evergreen because, the causes of crime are pretty complex. But again, a lot of this is just, it's generational. Why is it generational? To what extent is it nature? To what extent is it nurture? Don't know that we have a real clean breakdown a lot of the time, but there definitely appears to be both at play, and for a lot of, a lot of different reasons. And so that's always been the case. That's not really anything new. It's always been the case that if you had a parent that went to prison, it increased the likelihood that you might end up in prison yourself. Is that because you're more likely to be a criminal, or is that because you're more likely to have the police looking at you and in your family because of your your relative? It's all very complicated. Mental health as a whole, I mean, that's a whole problem. That's a whole issue we don't know how to solve. It's a very, very difficult problem. The sanitarium was better in some ways and much, much worse in others. It's just always about the trade-offs. It's always about the trade-offs. Music to my soul. Would they still have Judge if not for the change of venue? I thought he retired, so I'm not sure how that affected his assigned cases. He did retire. If they had not changed venue, they would have had him up to the point where he did retire. And so would that have gotten them to the point of trial? No, he's obviously already retired. But potentially would have gotten more, at least, out of it. Possible, is it possible he would have deferred his retirement because of the responsibility of seeing this case through to its conclusion? That's possible. I have no idea, but it's just kind of the read I got on Judge, is he was a very duty, focused kind of guy, and just a sense of, responsibility to the community and his role in it and stuff like that. So it wouldn't have surprised me, but of course we'll never know. That's just entirely, I don't want to say speculation because I'm not saying it would happen, but I'm just theorizing that is a possible outcome. Muserlina V. People are studying how much a person's affect influences opinion. Autistics feel deeply too. We just may not communicate them in the same way. Please don't make assumptions about people on the spectrum. Autism is very misunderstood. It's I don't want to be like frivolous, but I also want to kind of be able to shorthand things in a way that is, kind of everybody can understand. And so when I do things like, well, he's weird, with my finger quotes, he presents, yes, he presents in a certain way that pretty consistent to me with being on the spectrum. Of course, there can also be, comorbidities. There can be other things going on that we don't know about that influences a person's affect that aren't a cause of autism. And there's also severity. The more severe the autism, the less likely that there is intervention that's effective. Some things can kind of be trained and practiced, other things cannot. And then also the fact that this is a recent diagnosis for him, early diagnosis by and large is associated with much better outcomes than late diagnosis. So no, I do. I think it's important. I brought that up kind of with some hesitation, just because it's, yes, controversial. It's controversial, but this is an area of study that's out there. And I think it's important. It kind of, it relates to things like that we see with disproportionalities in criminal justice. We already know about racial disproportionalities. And yes, guys, those are very well documented, very well substantiated. You can account for variations that are the result of differences in perpetration rates, and you still end up with disparities that you know can't be accounted for other than just discretionary points. Pretty much every single discretionary point throughout the act of the life of a criminal case. If you look at you know a large sample of cases, you're going to find racial disparities in them. So to what extent it's that, to what extent, you know, there are differences in rates of perpetration, we don't know. That's why it's really important to study that and get more information about it. Joshua T, I'm curious for your opinion. Could Bryan get paid attorneys and try to file an ineffective assistance of counsel with hopes of getting a new trial? It will go nowhere. It will go nowhere because he's waived that. He's waived it. Ineffective assistance is, you know, you got to have a reason, you know, and ineffective assistance for what? What would be the allegation of what she didn't do, what she did ineffectively? We know that there are already kind of issues with the discovery. She made a record of that. There's just a massive amount of discovery. It's not really realistic to be able to go through all of it. But the standards of performance aren't necessarily that you have to look at every single piece of information that's provided to you. You just have to look at enough to be able to make reasonably informed decisions about what further investigation is necessary. And you also get to take into account information from your client. If your client, you know, tells you, hey, I did it and I'm going to plead guilty, and so you don't need to go down these roads anymore, then you're not effective for not going down those roads anymore when your client pleads guilty. So I don't really see a pathway here. But as with everything in the law, it's kind of it depends. It depends on the specifics, but very, very low probability in my opinion. Joshua T, the investigation is a failure, and why the roommate literally seen a masked man in their home and hid and didn't call 911 is mind-blowing to me. I know folks have had a lot of questions about that, and it's been one of the ones that's out there. Honestly, to me, the behavior of the roommates is one of the least concerning questions in the case. I don't have a problem understanding that at all. These are, you know, young adults, not a whole lot of life experience, not a whole lot of judgment. Very common to not necessarily have a lot of confidence in yourself and your perceptions and judgments and so forth at that point in point in your life. Complicated by intoxication. You know, seems to be some indication of some drinking happening in this house. Very late at night. You know, sleepy. To me, then you have just the trauma overlay on everything else. If you have something, you know, really scary that happens to you, it's not strange to me at all that people try to explain it away. You know, it's a self-protective thing that your brain will do. Oh, it's no problem. It's probably just this. It's not, you know. And I think you add that to the lack of confidence, the lack of judgment that you have when you're younger anyway. To me, that's not one of the bigger questions that I have. I think that's understandable. You would just tell yourself, oh, it was nothing, you know, I were just pranking and everybody was really drunk. And that's why you wouldn't be super worried about it as the morning went on until like it became really clear, hey, everybody should be up and moving around by now. And it's not. And that's when you'd start, you know, questioning your kind of self-soothing explanation that you gave. Literally, you know, just my opinion, but that's my take on it. Janet stuttered with a super sticker. Thank you so much for that, Janet. Appreciate it very much. To Truth for Liberty. Something very fishy still. Attorney Andrew Myers' channel poll shows over 50% still think BK is not guilty. You know, in any case, there's always going to be there's always going to be differences of opinion. You're always going to find outliers. You're going to find people that are going to, insist in the face of overwhelming evidence, which again is not what we have here. But you'll still have people, insisting for a variety of reasons that the person is innocent. Some of it is, coherent. Some of it is perhaps less so. There's going to be selection bias on channel polls. Who watches the channel is going to factor into how the poll gets answered. But I think there have been a lot of questions in this case. It's certainly not the majority opinion, I don't think, not from what I've seen. And I mean, even just the media studies alone that they did for the motion for a change of venue suggests the overwhelming consensus, even before there was, trial, any kind of evidence, any admission by Bryan Kohberger, was that he had committed the crime. So I think most people do think he's guilty. But I see a substantial amount of questioning, and questioning that's not unreasonable. Okay, I'm not gonna be gaslit into thinking that having questions about the how and the why are like necessarily, conspiratorial or problematic or anything like that. It's not, and it's justified because this is a very, very thin case. And so that's, again, just keep coming back to kind of my takeaway on this is just the unfortunate. It's the misfortune that they had the opportunity to try to get some more answers and just didn't even pursue it. You don't have to do anything at all with information that you get out of a plea deal. But if you got information and information that you could verify and information that answers some of these questions, boy, that could really go a long way towards giving that certainty that he's promoting to a lot more people watching this case. And I would put myself in that group. Mavka, BK is young bridge guy. He looks identical. He's a lot taller and thinner than bridge guy. I don't see the resemblance myself, but opinions may certainly differ. I love Kitty 73. Thanks for all you do. Well, thank you for being here with us. I love Kitty 73. Appreciate you. Claude Simeon. Oh my God, I thought Anders was an alternate name for Alfred. Shame, shame, shame. Hope you've seen Game of Thrones. Shame, shame. No, that was totally my bad. I realized as I was starting to say it for like the probably 20th time, I've been saying Anders this whole time. And of course, it's not Anders, it's Alfred. Anders is a different thing. That was my bad. I take full responsibility for that. Sometimes, guys, the wires cross. It's just, it is what it is. I get the wrong word sometimes. James Casatelli, this news conference is amateur hour. It could have been more helpful. I mean, at the end of the day, did it, leave us with a lot more reassurance? Not me. It just really emphasized more and more what they did not have. And yeah, they're limited, I guess, by the questions that they're asked, but you could frame your answer in a way that maybe allows you to kind of get out the information you wish you had been asked for rather than the information you actually had been asked for. The basic problem with it is they don't know. They can't give us answers that they don't have. Alaris Pilot, visitation rights for KB seems like mama's boy. Typically, yeah, they have visitation rights in prison. The way it usually works is you get to put people on your list, and your list might be limited. I don't know what the Idaho rules are. In Washington, I think it's 10 people you get to have on your approved visitor list. So if they're on your approved visitor list, they can come in to visit you. You'll typically have to do a background check. It's got to be scheduled. There's, whole process for doing it. But unless he is in some kind of closed custody, typically for a punitive reason, they'll not let you have your visitation when you're in the hole as a sanction. But like if you're in protective custody or something like that, often they are still going to give it to you. They may even be a little bit more flexible with it because of the fact that you're not being able to get some of the other freedoms. It's kind of awkward to say that in a prison context, but you typically you have a job in prison. You can go to school. You get rec. Various ways that you can spend your time. The biggest problem with jail, I get reported to me, jail, like local jail, is it's boring. That's the main complaint. It's so boring. There's nothing to do. It's not really the same when you get to prison. There's a lot more to do. Some of that is for rehabilitation reasons, and some of that is frankly just for management. People, predominantly young men who get bored can cause problems. They find ways to entertain themselves. How do young men like to entertain themselves? Well, sometimes it can get a little hands-on. So point being, if you're in solitary, you don't get any of that. So to kind of offset that and to keep you from being bored and losing your mind and stuff like that, sometimes there will be accommodations for things like special visits and stuff. Okay, just curious, is ineffective assistance still available for appeal? Yeah, very unlikely. Very unlikely. Again, it has to be something that's based in the record. So his very narrow pathway to appeal is circumstances that deal with his ability to enter the plea in the first place. Okay, so his competency to be able to do that. We don't have a record that I've seen that would support an appeal on that type of basis. Lack of knowing, intelligent, and involuntariness of the plea, that you can establish by, hey, my attorney was ineffective because they gave me bad information about what the potential consequences were, or what my rights were, or what I was giving up, by doing the plea. But again, if it's not on the record already, which it's not in this case, it's not available for appeal. You're going to have to bring that post-conviction. And then in that particular situation, you're going to be stuck with the problem now of the standard is manifest injustice. So if you said you were guilty, you admitted factual guilt, then how did the procedural problems, potentially hurt you? It really, really changes the dynamic a lot to have that concession of guilt. And then the only other real viable pathway is the illegal sentence. If Judge Hippler had said, forget the law, I'm imposing the death penalty, yes, he would be able to appeal that. But that's pretty much it. So ineffective assistance as far as it goes to reviewing the case, things like that, no, he's waived it. Post-conviction, available, possible. It's the likely avenue that he would pursue because it does tend to be one of the more just types of issues that you're more likely to be able to get relief on than, for example, like prosecutorial misconduct or something like that. But he's going to still run into the manifest injustice problem. You said you did it, so what does it matter if she didn't read all the discovery? Big game changer, that concession. Oh, I still have the banner up. Why did I do that? I always do that. Hilarious Pilot. Andrea, Alessi, AJ would be an amazing A team. Oh, I'd love to try a case with Alessi and and AJ. That would be fun. That would be fun. I don't think it'll happen, but we can dream. Hella, excited utterance. Hey, Hella, thank you for keeping the facts straight. There is so much fiction out there, and now it continues to be repeated till it becomes true. Please keep it up. this case has just been a nightmare in terms of the misinformation from day one. So difficult to tell the difference between, what's good information and what's bad information. And I feel bad for the good journalists that are trying to, dig and get information and present it. Because when you're in the sea of misinformation, there's no way of knowing if you're part of that or not. Who's the guy from the New York? He's like the local New York Times guy. He had done the piece on the claim that Bryan had been terminated from his TA position at WSU. And this is, it's out there. It's part of the facts, part of the, circulation of stuff. And there's just no way to know on its face. Like, I don't know if that's true. I don't know if, because there's so much that I've already learned you can't trust. I don't know if I can trust this. And so that's one of the upsides that I see from this big document dump is it's going to show us potentially who was doing the journalism and who wasn't, who was just like getting the gossip and whatever, because that story is substantiated in the document release, the being terminated from his TA position at WSU. So it turns out that was good journalism, but we didn't have any way to know that at the time. And it's a shame that the standards have become so low and that the lines have become so blurred that you can't tell. The right flux could saving money be what the prosecution got out of this plea deal? Sorry to sound so crass, but what say you? By the way, so glad to hear your take on this. That's the really obvious front and center one. And it's kind of the main one that we get from the explanation that we were provided. You don't have to go to trial. Why wouldn't you want to go to trial? Well, it's really expensive. And it does. That makes it sound like there's a cost. There's a price on justice for these victims. And if it's going to cost too much, then we're going to, go ahead and bend our principles and just go ahead and sell out, not do the trial. I mean, I very much hope that that's not the case. But again, like, okay, yeah, you save the appeal process and the potential for, whole bunch of appeals down the road, uncertainty that can engender. Yeah, it can. And having to go back and like do a new trial is a nightmare. It's like the worst case scenario. But you know how you avoid that? You run a clean fucking investigation. How many times do I have to say that? Play by the fucking rules and you don't have to worry about what could go wrong in an appeal. It's really not that hard. That's what you owe to the families, okay? Is do it right. And then you don't have to worry about that. And the process can play itself out. But you can be certain that things are going to be fine. Things are going to remain settled because you did things the way that you're supposed to. So I just remain baffled. I remain baffled. I really do. Don't know why. Don't know why they did this deal. Don't know why they did it the way they did. Don't know why they I've heard the explanations. They just don't make a lot of sense to me. Oh, Bryan Kohberger would lie. Well, but you're accepting as true his admission of guilt. Very selective, very selective. If you're concerned about it being true, ask for information that can be verified. Dan Smith, ploy to get another judge. I'm not sure what that means as far as like, appeal or something like that. Not going to happen. Not going to happen. I mean, you have to get the plea withdrawn. And you have to have a basis for that. You have to show, knowing, not knowing, intelligent, voluntary, and so forth. And if that happened at this point in time, it would still just go right back to Hitler. So I don't really see that as being explanatory for anything that we've seen in the case so far. Debbie J, apologies in advance if mentioned already, but just joining this live, what's the next case that you will be streaming? Well, this is the $1 million question because I'm not 100% sure. I'll tell you that if I do watch one in the short term, it's likely going to be the Donna Adelson. I know it's coming up in the next couple of weeks, and it's kind of interesting to me. So I only know about the case from the real like 10,000 foot view, because way back in the day, I used to read Instapundit, and Glenn Reynolds would talk a lot about the case long before anybody had ever been charged, because Dan Markle, the victim in the case, had been a law professor. And so I just sort of knew about it, but then I really didn't follow Charlie's trial at all. Charlie, the son, the brother of Wendy Adelson, who had been married to Dan Markle, really didn't follow the trial at all. But Donna seems like an interesting one. I do still have questions about Wendy, and she has not been charged. She's the one that would seem to be most complicit. It's like a murder for hire scheme. She's the one that like benefits from that. So, is this something mom and brother would do without her involvement? I don't know. Seems like a bit of a stretch, but Donna Adelson also seems like not your normal run-of-the-mill mom. So that one I would say is the most likely one that I will be watching in the short term. So I will let you know, though. Stay tuned. I'll do a community post if I make that decision to do it. I just need to do a little bit more research into it, get a sense of like what the time investment is going to be and so forth. Ladybug Lisa, I really thought Ann Taylor looked run through the ringer at plea and sentencing, and I wonder if he conned her about innocence. 100% speculation, of course. Is it true he could or did request female counsel? I have not heard any kind of substantiation of that. And it likely wouldn't matter anyway what he wants. You get what's available for death penalty qualified counsel in northern Idaho at that time. It was up in Latah County, and that meant you got Ann Taylor. Like she was it. Like she's the option. Eliza Massuth is also in northern Idaho, but she's in a more remote county. She was the only other one qualified to take it on. So he was gonna get a female one way or the other. I also thought that she does. These are hard. These are hard processes to go through. Regardless of kind of what led up to it. If there was like a breach of trust with Bryan or anything like that. It's hard. These are very emotional. You're very cognizant of the fact that people are suffering, and that you have to kind of be at arm's length from that, because it's not your place. You're here to represent this person, and it's an adversarial system. It kind of necessarily puts you in opposition, legally speaking, from the victims. But it doesn't mean that you don't have, enormous sympathy for them and appreciate their pain and don't want to contribute, to more of it. These are hard cases, very, very hard cases for everybody. Kim and Oak, what would you consider a good case for prosecution and make you believe he is guilty? Evidence is overwhelming. Respectfully, is your channel always defense or unbiased view serious? Because I will watch it from a different lens. Well, in terms of my channel, my background is as a criminal defense lawyer. So that's the perspective that I bring to it. I understand how criminal defense lawyers look at and engage with cases. Does that mean I think every defendant is innocent? Oh, absolutely not. Like, as I've said, even in the course of this stream, the high profile cases are selective. You know, they're not representative of the vast majority of the volume of what goes through the criminal courts. And the vast, volume of what goes in through criminal courts, people did do something. Okay. The issue is it the actual crime that they were charged with? And is the punishment that the prosecution wants for it going to be suitable? Were their rights violated in the process of, getting evidence to be able to prosecute them? That's where the vast majority of your legwork is done as a criminal defense attorney. It's not defending factually innocent people. Yeah, they show up in court, but it's not really that common. So I'm completely open to finding people guilty, completely open to that. I'll give you an example of a case. I brought this up a few times because it is, from my perspective, it's a good contrast to kind of the strength of the evidence against Bryan Kohberger, because both of them are circumstantial cases. And so when you're dealing with a circumstantial case, what you're typically looking at for evaluating how strong the case is how much corroboration of the same circumstances can you get? And so the counterexample that I would give you is the Long Island serial killer, the Rex Heuermann case. If you read through the probable cause affidavit in that case, you get a very, very different picture of how that corroboration can look, because you will, have DNA, but you'll also have it corroborated with the internet searches. You'll have it corroborated with his location data. You'll have it corroborated with his travel plans. You'll have it corroborated with him being on video. This particular case, there's a lot of inference that goes into making some of these connections. The car, for example, is, I think, a great one. We've seen through the motions in limine and some of the pretrial litigation what some of that video footage was, what some of the basis was to say this is the same car, that we're tracing through this location. And I got to tell you, the police don't have magic eyes. They don't have a better ability to be able to look at a grainy, image of a smeared, white something on the street and be able to say, recognize this is a 2015 Hyundai Elantra. So you can use your own eyes and make your own judgments about how strong of an inference is this. It's not nearly as strong as, for example, Rex Heuermann buying freaking plane tickets, to go to the place where he's supposed to be. Again, GPS data versus the phone pinging off of a single tower. It's a dramatic difference in the precision of the information that you get. And so you can draw a much stronger inference. If I have GPS data that says, this person was at the crime scene within a range of 6 feet versus this person was at the crime scene within a range of 10 miles. So that's the difference that I see. They did not have, from my perspective, a substantial amount of corroboration of Bryan Kohberger's guilt. Does that mean he didn't do it? No, of course not. And he's, again, said he did. It just doesn't make it a strong and overwhelming case. CRG, amazing, insightful coverage. Thank you. You are the best. Well, thank you for that. Very kind comment. Really appreciate it. Oh, I see. Kim and Oak, if I'm saying that right, said, just generally would like to see you do a pro prosecution case. I am very interested in the Long Island serial killer case. That's one. It's just, it's, probably down the road still. I don't think they even have a trial date on that one yet. Based on what I've seen so far, if they can prove what they have in the probable cause affidavit, yeah, I think he's guilty. I think he absolutely did it. So that'll be one that you can keep your eyes out for. Wendy Adelson, or I keep saying Wendy, but it's Donna. Maybe I just want it to be Wendy. I don't know. No, it's Donna. Donna Adelson. Don't know enough about it at this point. I know Charlie was convicted, and didn't look great. I don't know how strong the evidence is of Donna's involvement, but I'm super inclined to give her, you know, a huge benefit of the doubt under the circumstances in that case. So honestly, probably the main reason why I don't watch a lot of pro prosecution cases is just because they aren't that interesting to me from a legal standpoint. Daryl Brooks is a great example. You know, Daryl Brooks, he's on freaking video. Like we know it's him. We know he's guilty, but we're going to go through this trial process. Why? Well, because he has the right to do it, but he's, you know, wanting to make it a sideshow, and that's kind of what it was, and that doesn't interest me as something to watch. Like, I'm not here for the spectacle. I like cases that are legally and factually interesting and complex, and so that is going to probably skew me a little bit more in favor of cases where maybe factually it's not so clear what happened. But yeah, Long Island serial killer is the one I would say to keep an eye out when and if that ever goes to trial. I'm going to probably be leaning on the prosecution side on that one. Lil Har Oak, would state's evidence S1 ever have been handed over to the defense without having taken the plea deal? Jennings turned it over 7/7/2025. It's a good question. I don't know. Let me see if I can pull up real quick the just the docket, because I forget the timeline as far as when the request for that particular discovery had been made. Let me see. Yeah, it was the 24th supplemental request. And so that was only issued, the defense only issued the supplemental request on June 25th of 2025. So kind of hard to say. Like, no, they probably wouldn't have. Is that a problem though? Not necessarily. If it's not mandatory disclosure, then it is something you have to ask for. And it does seem like they did timely turn it over. Now, having said that, I did see when kind of around the time the plea was happening, when I was like getting caught up on everything, I saw people kind of wondering, like, why? Okay, the plea happened, but now they're still producing discovery. Why are they doing that? Theoretically, you know, it's possible that you could just agree, you know, hey, forget about it. We don't need to, you know, we don't need to go any further down this road. We don't need to do investigative stuff. But what it does is it takes off the table the possibility of them arguing if Bryan wants kind of an easy out of the plea, he's changed his mind and he doesn't want to do the plea anymore, from being able to argue, hey, my plea was uninformed because we had this outstanding discovery request and we never got an answer for it. And so, you know, this information, you know, maybe played into my decision to plead guilty. And so it's just basically taking it off the table for him to try to argue that not producing it somehow undermines the validity of his plea. But I mean, yeah, absent the plea deal, like it probably would have been turned over because it was requested, you know, so they did turn it over. I don't really have a reason to suspect that. Truth and transparency. Hey, Lana, the day I go from A's to big D's, which impact statement was most impactful? Well, we watched it. It was Kim Chile's, in my opinion. She was everybody's Deedle on Wednesday. And I appreciated her so much. I thought it was extremely powerful, extremely compassionate. She's a woman that I've never heard of before, and I already admire the hell out of her. I would love to see her, you know, write a book or have a show or something like that. She just seems like somebody with a lot of wisdom to share. So I appreciated that very much. V Grave, the 911 call is still bizarre. Supposedly everyone's been stabbed, but roommates report one drunk, unconscious roommate. The cop receiving the info from operator already knew it's an unconscious female. I mean, so in the recent documentary, they did give an explanation for that. That was Hunter, and Hunter said that he told the girls that it was unconscious. Like he knew that they were dead, but he told the girls unconscious to try to protect them, from trauma, basically. And it makes sense to me. I don't expect people to act rationally under those types of circumstances. I mean, I got to tell you, like, everything else being equal, I kind of think that might have behaved a little bit more rationally than I might expect. Like that's a horrifying thing to face, and your mind is programmed to keep you safe, keep you out of danger, and so explaining away stuff, sometimes even just like flat out, you don't even see it. Like this, it sounds crazy, I know, but it does. It happens. Trauma is incredibly wild. So I personally, don't have a whole lot of questions about that part of it, because to me, honestly, there is little that they could have done that I think would raise my eyebrows. Like I would expect far more abnormal, behavior than I think we saw. That's, again, just my opinion, but TB85, Megyn Kelly went off on the LEO after their press conference following sentencing, said she's unsatisfied. Oh, I didn't watch Megyn Kelly, but sounds like we are on the same page about that. Yeah, I'm dissatisfied too. It just doesn't make sense to me. The biggest thing that doesn't make sense to me is, why would you not try to get more answers? And I don't buy the explanation. He's going to lie, but you're going to accept his guilt, his admission of guilt as being truthful. You have the possibility of being able to verify it. You don't have to put it in a situation where he's saying it, in front of the families, where he could victimize them. The very fact that he's taking a guilty plea where he acknowledges guilt seems to me to not really be consistent with wanting to victimize the families. So, yeah, speaking of self-serving, those explanations seem like that to me. I am also dissatisfied. Claude Simeon, please remind, do you still practice or just YouTube now? So I am nearly retired from the practice of law. I still have one appeal hanging out there almost 2.5 years after I stopped. I gave up my contract. Still got a case out there, guys. That should tell you everything you need to know about the appellate system and the broken public defense system as well. But I'm essentially just waiting for that one to resolve. And then I don't really have a formal legal practice. I haven't really decided yet what I'm going to do. I don't really consider like just YouTube, because let's be honest, guys. I hardly do YouTube. Like I'm not all that good at it. I don't want a job. I've said that many times. Very fortunate to be in a position where it's not something I really have to worry about. The biggest reason why is because I don't have kids, so I haven't had to worry about paying for kids and stuff like that. So I don't really consider YouTube like my job or my career or anything like that. I would do it a lot more and probably be better at it. I'd be much better at the grift if that's really kind of what I was doing. But it's fun. That's why I want to do it. It's fun. It's insightful. I found it meaningful, just to kind of help share what I know about the process and help educate people about what it looks like and what's kind of going on behind the scenes. And I find it super enlightening and often really, really edifying to see what just normally people think about what's happening, about what they're seeing, and in the process and in their own backgrounds and stuff like that. So to me, it's just like a big, awesome conversation that you might have like in the coffee shop or the bar or something like that with with people who are interested in something that you're interested in. And so I do plan to continue to do that. I want to keep having these conversations. Marcelo, motion for Judge Andrea to review the Arkansas father case. Trial is in September and the judge doesn't want cameras there either. Glad to have you back. I've been having Andrea withdrawals, so I'm glad to be back. I did take a little quick look at that case. Of course, as you know, there's not a whole lot available because, yes, it's another judge that's allergic to transparency. And so a lot of the case file is under seal. But this is the one where the father has been arrested and charged for basically what happened. He woke up in the middle of the night. His daughter was not in her room, as his teenage daughter, I think she's 13 at the time, was not in her room. She had previously been abused by a ex-police officer, basically friend of a friend, ex-police officer with a history of these types of crimes against children. And so there was a pending prosecution against him. He had been charged, but he had been released on bail. So she turns up missing from her bedroom. They, call 911, go and look for her. Father happens to find the ex-cop's truck on the road, tries to get him to stop, doesn't stop. He rams the truck, runs it off the road. Ex-cop comes out and, comes at him, basically. Not a whole lot of detail about the circumstances, but basically he ends up shot and killed. And father's been charged with that. So it's a case that has a lot of very, very strong feelings about it. It is one that is legally interesting to me, because it's a self-defense case. And, I look at cases with nuance. I look at what the law is. I look at what the facts are. And I take the unpopular position that I can see why the charges were brought, given the facts of the case. There was, rather large amount of force used. Not entirely clear that there was an imminent threat, like immediate threat that typically is what you need to justify the use of force. That said, don't think he's going to get convicted. Don't think if I was on the jury, with what I know right now, I'm not convicting him. But it is just interesting from a legal standpoint. So if we are able to see more about that case, it's one I might take a look at. Gypsy Girl, how about the All-Star game? Yeah, how about Kyle Schwarber single-handedly winning the All-Star game by being clutch as fuck? Oh my God, it was great. It was great. It was a great game. Unfortunately, of course, there's a rather long and storied legacy of Phillies collapse after the All-Star break. Hoping we're not seeing that. I see that we're way up on the Yankees right now, 12-5, something like that. So that's good. That's good. But we got to get back ahead of the Mets, guys. We're half a game back from the Mets. We cannot let this stand. This is intolerable. So I didn't see who the Mets are playing now, but the Giants. Go Giants. We're in a go Giants stage right now. So oh, well, guys, it's been fun to be back, and I'm glad we had the chance to kind of go over this. I know I had a lot of people, wanting, Andrea, want your take, we need your take on this. And I definitely wanted to give it to you. This is, of course, a case that I followed for a long time, had a lot of thoughts about. And so I did feel a responsibility to come in and kind of walk us through what I saw and my takeaways from it. I'd love to be able to wrap things up with a nice, tidy, happily ever after ending kind of bow. But you just don't get those very often. That's part of the reason why when you get like a Karen Reed not guilty, it's such a cause for celebration. because often it is rare. Unfortunately, dissatisfaction is a pretty normal state of affairs in the criminal justice system, and for a whole variety of different reasons. So would have been nice to have had a different outcome here, a little bit more certainty, a little bit more just questions wrapped up. Ashley, Andrea, you're so much more authentic than the other YouTube streamers. Please do it more and don't change a thing. Well, thank you. I learned a long time ago from trial work that people can smell bullshit a mile away, If you're going to go and make an argument to a jury, it better be one that you can believe, because if you don't believe it and you're just trying to insincerely put something out there, they're gonna smell it on you. Like it's gonna be crystal clear that you're being insincere. So I learned that, and that meant as a lawyer, sometimes you got to get creative about what your basis is. Sometimes you don't have a lot. Sometimes, because it's your client's choice whether to go to trial or not. They don't have to follow your advice. You just make recommendations. Important thing too to remember with the plea deal. Nobody forced him to do it. You can make recommendations and that's it. But sometimes all you got is just ladies and gentlemen of the jury, the state bears a heavy burden of proof beyond a reasonable doubt, and we'd ask you to hold them to it. Thank you. That's just the best you can do. So it's just important to me to try to be real and say what I think, because I don't think any of this is helpful to anybody if we don't. So with that, guys, I do appreciate all of you joining me today, being here for this. And yeah, guys, this is the end. And I put that little ellipsis at the end. It's the end because it is the end, but unfortunately, it's not. It's not really the conclusion as far as answering all of the questions that we'd like to have answered. Hopefully, there will be more in the documents, both the stuff that the MSP has released and in the stuff that is going to get unsealed by the court. So I'm going to be continuing to watch that. If I, find stuff that seems like it's worth having a conversation about, well, then maybe it's not so much the end, and we'll talk about that some more. But yeah, at the end of the day, now we get to race to make up for the lack of transparency that we had throughout the whole process of this case, and try to see if that was justified, not justified, and get a better idea of maybe why this resolved the way it did. Don't know, but all we can do is read what's available and see. So with that, guys, thank you so much for joining me. Do appreciate it. Appreciate your support after I can disappear and vanish for weeks and into the woods, and you guys will still show up. It's very flattering. I do appreciate it a lot, but it also does give me a lot of encouragement to keep going. So I will keep an eye out. I will do a post when I let you know for sure what my next plans are going to be as far as a trial to cover. And hey, if I don't see you before then, I'll see you when that happens. So take care, guys. Enjoy your evenings. Enjoy your summers. And it won't be long. I will see you soon. Take care, everybody.